Yeah. Testing, testing, 1, 2, 3. Testing, testing, 1, 2, 3.
Palumo.
Like, what's on the website? It's right.
No, he's with the commission.
Oh, okay.
He was part. He's who we had a yeah.
Buenos días. Aún no va a comenzar la audiencia. Vamos a tomar unas fotografías y luego comenzamos la audiencia.
We will be starting shortly. Please be seated. We are taking photographs and we'll be with you very soon. Thank you.
Cuando terminen las ponen.
todo? Yeah, no worry. I'm gonna give some information and then we're gonna start. Ah, me parece una buena idea. ¿Listo? Muy buenos días nuevamente, señoras y señores. Vamos a dar inicio a este tercer.
Good morning, ladies and gentlemen. We are about to begin this third day of the hearing on climate emergency and human rights, the request for an advisory opinion by the Republic of Chile and the Republic of Colombia. Please go back to your seats. Please do not place your personal items on the seat next to you so that more people can enter the room. We would remind those who will be speaking in the different panels today that you must come half an hour before the panel begins so you can be seated by the court officials. Also, the first rows of black chairs are reserved on my left for the delegations that will be speaking in the session, and on the right for the different delegations. And again, court officials will make sure the seating is done correctly. I would remind you that we are providing simultaneous interpretation services. You can request a receiver at the door to the room or use your own cell phone. In either case, do remember to keep the screen of the device open, because if the screen turns off, then the transmission will be interrupted. Finally, I would remind you that this hearing is being broadcast live over the court's social media. You can find the links in YouTube, English, Facebook, Spanish, on the website of the court. If you have any problem finding that, please talk to anyone from the Secretariat. We are here to help you. Ladies and gentlemen, please rise. The court is entering the chamber.
Muy buenos días
Good morning
a todas las personas que nos
to
acompañan
all those who
presencialmente
are
y a
with us
través de
here
nuestras redes sociales.
on site and over
Se
the
reabre esta audiencia
social
pública sobre la
media.
solicitud de opinión
We are
consultiva
reopening this
presentada
public
por la
hearing
República
on the
de
request for an
Chile y
advisory
República de
opinion brought by the
Colombia
Republic of Chile and the
sobre los
Republic of
temas
Colombia
relacionados
to
con la
discuss
emergencia
issues
climática
involving the
que
climate
planteados
emergency
a esta Corte.
that they have
Esta audiencia,
submitted to the
como
court.
ustedes saben,
As you know, this hearing,
tercer día de sesiones de
this sitting is the
periodo
third day of our
de sesiones
166th
ordinarias.
regular
Escucharemos
session.
esta mañana
This morning
y tarde
and this afternoon,
un
we
total
will
de 10
hear a total of 10
intervenciones divididas en 4
interventions
bloques.
divided up
Cada
into
bloque
4 blocks.
seguido
Each block will be
de las
followed
preguntas de mis
by a
colegas
question and
jueces
answer
y
session
jueces.
by my colleagues, the judges.
Doy la más cordial bienvenida a todas
I
las
would like to
personas
welcome
comparecientes
all the people who will be
y
speaking
agradezco
before
en
the
nombre
court
del
today,
Court
and on behalf of the
su
court, we
interés en
thank
este
you for
procedimiento.
taking an
Hoy
interest
nos
in this
distingue
process.
su presencia
Today, we
la
are honored by the
del
presence
principal of the West Indies
of
Cave
the
Hill
principal
Campus,
of the West Indies
Carlandis.
Cave Hill
Un
Council,
gusto
Carl
tenerlo en
Landis.
esta
It is a
audiencia.
pleasure to have you here with us
Igual al
today.
Vice
Also, the Provost,
Dr.
Chancellor, Dr. Antonio Hippolyte,
It's an honor to have you here. Y a las autoridades de la
and
universidad,
the university authorities
gentileza
who were kind
de
enough
nuestro
to
periodo de sesiones.
join us in this
Hoy es un día
session.
especial, hoy
Today is a
daré
special
paso al
day.
señor secretario de la Corte,
I
señora
will
señora
not be
secretaria
recognizing
adjunta,
the registrar of the court, but the assistant registrar, Romina Sinjensky, who today is wrapping up her final session with the court after 17 years of service. This is a token homage. We want her to lead her final hearing. It's in recognition, Romina, for your extraordinary work and performance here in the court for so many years and for your many contributions to the inter-American system. The judges are going to rise in honor of her, and we would ask the audience to do so as well and give her a round of applause.
Señora secretaria adjunta de la Corte,
Madam Assistant Registrar of the Court, I will now recognize you and ask you to give the instructions for this hearing. Please proceed, Romina. Thank you very much, Madam President. Good morning to everyone who is here. Thank you so much for this recognition. It's very moving for me. This morning, the following delegations will be appearing before the court: the Ruta del Clima Association, the Inter-American Association for the Defense of the Environment, the Central for International Environmental Law, the International Network for Economic, Social, and Cultural Rights, and the Ruta del Clima Association. Number 3, the World Youth for Climate Justice. 4, Caribbean Environmental Law Unit of the Faculty of Law at Cave Hill. 1 Ocean Hub, Renew TT, GNHRE Caribbean Region, and AIDA Caribbean Branch. Number 5, Elisa Fornal, Veronica Bilkova, Lawrence Bugord Larsen, Federica Cristani, Sara Devido, Curtis Dobler, and Anne Hertogen. Number 6, the Information Center on Private Companies and Human Rights, the Attorneys Collective Jose Rafael Recepo, CAJAR, Pax Christi International Program for Latin America and the Caribbean, the Environmental Committee in Defense of Life. Number 7, the Civil Association for Equality and Justice, ASIG, the Center for Legal and Social Studies, CELS, the Fundar Center for Analysis and Investigation and Research, the Center for Economic and Social Rights, and the Association Ruta del Clima. Number 8, Eulalia Petit de Gabriel and Iraida Jimenez. Number 9, the Association for the International Code of Conduct, the Arias Foundation for Peace and Human Progress, the Institute for Instruction on Sustainable Development, the Geneva Center for Governance of the Security Sector, the Legal Advisory Service of the El Bosque University, the Institute of Studies for Development and Peace, and other experts on the subject. And finally, number 10, we will hear from the Center for Gender and Refugee Studies, the International Refugee Assistance Project, the Global Center for Legal and Environmental Studies at the Elizabeth Hobbs School of Law of Pace University, Sir Arthur Lewis Institute of Social and Economic Studies of the University of the West Indies, the Americas Alliance, Refugees International, and Shana Tabak. I would ask those appearing before the court that in your oral submissions you express yourselves slowly and clearly in order to facilitate the work of the interpreters, and please respect the time limits that have been assigned. We would also ask you, when you begin your words, to tell the court the name of the person who will be taking the floor. That's all. Thank you, Madam President. Thank you, Madam Assistant Registrar. We will follow the order as established in advance. Therefore, we will now hear from the representatives of the Ruta del Clima, the Route of the Climate Association. Good morning. Ladies and gentlemen of the court, I'm speaking for the Central American Ruta del Clima. Loss and damage is the daily life of the community Toma del Agua of Chiquimula, Guatemala, who because of the drought are unable to grow their beans and rice to eat. They are the fishing women of the Colonia of Honduras who cannot fish because of the storms and have to go home without fish. Or the families of Cedeño Beach who are suffering from the tidal waves and are unable to fish. The Cahuita community and their national park, which is eroded by the rising sea levels, destroying biodiversity and jeopardizing their people and culture. It's the struggle of the communities of Puerto Rico that are experiencing the settlement and loss and damage where exclusion and gentrification are taking advantage of their vulnerability. The community of Yunayala of Guajira, Colombia, who see their crops threatened by the adverse effects of climate change, the thousands of women who every day are facing hurricanes and drought, who live with hunger, with crop loss, and see that and their ecosystems are degraded. They are victims of climate collapse, and they see the problem of child care in their communities and are victims of violence in this crisis. They are alone before the economic costs, so alone against the loss and damage. We've seen how, and we've visited communities in Guatemala, Honduras, El Salvador, Costa Rica, Panama, Puerto Rico, Colombia. We have heard and seen how their communities are fighting for their dignity given the loss and damage. Thank you for the privilege of being able to talk to these farmers, fisher folk, and leaders to talk about their daily lives. Loss and damage is the impact that people cannot bear or adapt to that cause irreparable damage or irreversible loss. Loss and damage may mean a loss of economic and non-economic factors of life, such as culture, traditions, languages, when they are forced to leave their homes in order to save their lives. Today, we are before the Inter-American Court of Human Rights to ask that you clearly delimit the legal obligations that the states hold, given the loss and damage caused by the adverse effects of climate change and in consideration of the human rights of the most vulnerable people of our region. Loss and damage have been caused by when the states violate their long-term obligations to prevent cross-border damage, respect and protect human rights. This international misconduct should force the states to provide reparations for mass violations of human rights for the loss and damage caused by state actions or omissions. Climate change is caused by the direct and indirect action of the effect of human activity. Economic actions that have released thousands of tons of greenhouse gases into the atmosphere, providing profits and benefits that are out of proportion for certain sectors, while having such an impact on vulnerable populations. Article 8 of the Paris Agreement reiterates the duty of the states to face damage and loss in harmony with the provisions of human rights and international law. The Human Rights Council recognizes that climate change is an existential threat and that the adverse effects of climate change have consequences for the effective enjoyment of human rights. The continuous production and increasing use of fossil fuels condemn all of us to suffer losses and damages that threaten our existence. The UNFCCC Article 1 recognizes that climate change causes changes to the physical environment and the biota, which has damaging effects to the composition and ability to recover, and on the function of socioeconomic systems. These devastating effects are what we reproach and report from our own territories. The adverse effects of climate change are the result of cross-border environmental damage. The International Court of Justice has recognized the general state obligation to guarantee that all activities under their jurisdiction and control would respect the environment of other states or other areas beyond their national control. This includes the obligation not to allow the use of their territory to cause damage to their residents or properties when there are serious consequences and the damage is verified convincingly. The principle of prevention, as the Inter-American Court has said, is the obligation of the states to take measures to prevent environmental damage before it occurs, including by adopting measures to reduce, limit, or control activities that could cause or create the risk of damage to the environment. The International Court of Justice has said that the principle of prevention is an international standard for environmental protection, especially considering the irreversible nature of environmental damage and the limitations of mechanisms for repairing damage. The states have the duty to protect the atmosphere in accordance with the Resolution 76-112 of the General Assembly of the United Nations. The interpreters are asking if you would slow down, please, and speak a bit slower. That warns against atmospheric degradation and its damaging effects to the environment and human systems. The states parties to the Framework Convention have the duty to take measures of precaution to anticipate, prevent, or reduce the causes of climate change and its adverse effects in accordance with Article 3.3 of the Convention, Human Rights and International Environmental Law. This duty explicitly calls for dealing with the serious or irreversible damage, taking comprehensive measures and policies that consider economic sectors and contexts. Article 2 of the Convention defines the responsibility for prevention, such as stabilizing concentration of greenhouse gases in the atmosphere that interferes with anthropogenic interference in the climate system. Stabilization must take place quickly enough for the ecosystems to adapt naturally to climate change and ensure that food production is not threatened so that economic can continue sustainably. But this has not been done. Atmospheric change has increased significantly over its levels of 1990. The IPCC, in its most recent report, expresses with high certainty that climate change caused by the human race has caused widespread adverse impacts and losses and damages associated with nature and people. Of Human Rights has established that it is a principle of international law and also a general concept of law that every violation of an international obligation that has caused damage entails the duty to redress. We have the right to climate reparation. Repairing the damage caused by the violation of an international obligation consists of full restitution. This entails restoring the situation as it was before and repairing the consequences of the infraction. International environmental and climate law does not restrict or limit the responsibilities for repairing climate damage or deaths and loss. Instead, the principles and objectives of the Paris Agreement and the Framework Convention provide a basis for the pre-existing obligations of the states and include the fundamental obligation under human rights law to prevent and correct violations. To meet their obligations, the states must implement mechanisms to restore damage to restore the status to its earlier state by including restoration, compensation, or payment of economic sanctions and the financial instruments needed to support repair. This means transferring public financial resources from the largest emitters to pay for reparation for loss and damage. We note, however, against the commercialization of suffering caused by loss and damage and the transformation of victims into consumers of financial services. To close, the states, by means of paragraph 51 of Decision 1/COP21 that adopted by the Paris Agreement, have decided that loss and damage do not entail or make room for any form of legal or responsibility or indemnification, overlooking the principles of international law, making populations more vulnerable and exposing them to human rights violations. We would ask this court to outline the state responsibilities for loss and damage caused by violation of their obligations to prevent cross-border environmental damage and protect human rights, leading to the obligation to provide climate redress. All we ask for is justice. Thank you.
Thank you very much to the representatives of La Ruta del Clima for your participation in the hearing. And we now give the floor to the Inter-American Association for the Defense of the Environment, the Center for International Environmental Law, International Network for Economic, Social, and Cultural Rights, and the Association La Ruta del Clima. Please proceed. Good morning, Honorable Inter-American Court and distinguished members. I am Angelica Corredor. I am a young person from Colombia, and I am part of the Committee to Defend the Life. and for the general community. I am here representing the International Network for Economic, Social, and Cultural Rights, integrated by over 280 organizations, social movements, and activists in the world. I appreciate the opportunity for addressing you on behalf of communities affected by the climate crisis in Latin America and especially Colombia, because this is a stage where we have to seek justice, safety, and ask for noxious actions to stop, and integral or comprehensive reparations. We cannot accept the unacceptable consequences of damage to the environment. As a young person, and in the midst of this environment, I am faced with confusing discourse by international leaders and politicians that do not take effective action to protect our communities that are suffering the impacts of climate change, while production and the use of fossil fuels continues, as well as agro-industrial deforestation. From our communities and villages, we say that the world cannot let you continue destroying rivers, trees, animals, just to get material richness and individual interests. The half of the world's population, that is the poorest, has not contributed to most of these emissions, and the rich part of the world is responsible for more than that. So what is the future, the quality of life of women, children, and those and the homeless that are facing the catastrophic events of the climate crisis, based on a lack of capacity and strategies to resist to climate events that are the result of abuse of the agro-industrial actors and the fossil fuel industry, and mostly from the global north. As I've said, climate change has led to economic and non-economic damage and loss. In my own community, Saldaña, this small village does not have a sewage system, and so we have to use our water from wells. The depth of wells is growing. It's much more difficult for us to get our water, which is vital. This is caused by climate change and the intervention of mining companies that have made us more vulnerable in the past years. Extractive activities have changed the course of the river with less flow and impacting its biodiversity as well as our population. There's more erosion and particulate matter in the air we breathe, and we are now facing problems of food sovereignty with our crops contaminated. These are devastating effects for our community and the intrinsic value of nature. And it is not an isolated situation, not just in our territory. It is an X-ray of what is happening in all territories in Latin America. In January 2024, the Berlin highlands in Santander suffered damages after a wildfire that burnt down more than 200 hectares. We have several species that are important to regulate water production and availability. They need more than 50 to 100 years to grow and to just be 2 meters in height. In Colombia, climate has changed so much that we are now seeing events we had never had before. Hurricane AIDA devastated San Andres Island. 80% of it suffered grave economic damages, and 100,000 and more inhabitants were damaged. There were losses in tourism, culture, heritage, mangroves, forests, and marine ecosystems. The country has also suffered from landslides after torrential rains, and this year the greatest disaster we've had was on January 12th. There was a landslide in Antioquia with at least 33 people dead and several vehicles swept away. Coastal erosion is also one of the clearest losses and damages after climate change. It is a consequence of rising sea levels, and it has led to changes in our cultural and social dynamics. With all this in mind, social movements, young people and women ask for justice and reparation for those who have caused these impacts, to take on their responsibilities and to stop their dangerous ways and to pay for the impacts we have suffered in our communities. We know that international negotiations on climate negate these types of reparations, and there's just voluntary funds that are seen more as a charity. And these types of funds do not allow us to get full reparation and the capacity to work at the necessary level. Although we do need resources, this is not enough. We have a right to comprehensive reparation, not just monetary payments, but restitution of lands to meet our basic needs and the guarantees of non-repetition. For 3 decades, climate negotiations have not provided reparations to the communities that have less influenced the current climate crisis and the ones that are suffering these damages the most. We call for justice and ask the court to make decisions to guarantee our full exercise of human rights, as well as urgent action to address loss and damages brought on by the crisis, and to ensure differentiated responsibilities are shown between the global north and global south, with a priority to individual and collective rights, and acknowledging those communities that have been affected as rights owners and having the right to full reparation. The law is clear, as the court itself has said, and as conventional international law states. When an international obligation is violated and there's damages, it should lead to comprehensive reparation. Thank you.
Thank you for your presentation. We will now hear from World Youth for Climate Justice. Please proceed. Honorable Court, Registrar of this Court, human rights cannot be respected or guaranteed within the context of the climate emergency if we do not first recognize that vulnerability to climate change goes up proportionally to the date of birth of each person. A child born in 2020, 4 years ago only, will suffer 7 heat waves more than someone who was born in 1960. Twice as many floods, droughts, and crop losses. What can we expect from the conditions in which people will find themselves who will born in future years, or the future that those born over the last 30 years can aspire to? My name is Mariana Campos, and together with my colleague Aditi Shiti, we represent World Youth for Climate Justice, an organization led by youth from around the world. It is a great honor to come before this court, and also it shows quite clearly the responsibility and the active role that we must take in the face of the climate emergency, because me being here as a student in this room, pleading for an habitable future for myself and future generations instead of being in a classroom, shows that we're walking down a path that is runs completely contrary to science. This reflects a burden that we are taking on to ensure a better future. And that is why I would like to help this court look at the obligations that are incumbent upon the states about children, youth, and future generations. First of all, I'll talk about the vulnerabilities and the the effects that these future generations and youth are liable to experience. And my colleague will talk about intergenerational equity and the intertemporal dimension of these obligations. The science behind this climate emergency cannot be seen or understood if we do not put a face to the statistics. Scientific consensus shows us that GHG emissions will bring about irreversible changes that pose a threat to ecosystems, biodiversity, livelihoods, health, and the well-being of present and future generations. On the other hand, this court, in the judgment of the community of La Oroya versus Peru, paragraph 143, acknowledged that children are particularly hurt by climate change. First of all, for the way in which they experience its effects, and also because climate change will have an effect throughout their lives unless something is done about it. This was also seen in the case of Chiara Sacchi from Argentina and Catarina from Brazil, to name a few children that demanded major cuts in GHG emissions in their countries before the Committee on the Rights of the Child. We believe that a similar interpretation must be extended to the youth, and having youth between 18 and 30 years of age be seen as especially vulnerable to the climate emergency. And that is why this court has also recognized the need for reinforced protection for children. And youth are especially affected because they cannot realize their life plan in the same conditions as previous generations. And also, they are discriminated against as immature when they try to get involved in public affairs. What is shown through the growing criminalization of young defenders and activists. Although we cannot say that youth are just as vulnerable as children, but they must be considered more vulnerable than older generations. Finally, children and youth are those closer in time to future generations. So they have an important position in this transition towards an intergenerational type of thinking in the long term. States must acknowledge their right to be heard when they advocate for their own rights, and even when they advocate for the material interest of future generations to enjoy the same biological, natural, and cultural diversity, the same quality of environmental goods, and the same access to opportunities as previous generations. In view of the above, it is necessary for states to comply with their duties for respect and guarantee vis-à-vis current generations, especially children and youth, and also future generations whose material interest to live in dignity on this planet, it also involves our own interest to preserve our own species. I will now give the floor to my colleague, who will elaborate on intergenerational equity and the state's duty of prevention. Please speak slowly.
Honorable Judges, Madam President, Honorable Secretary of the Court, my name is Aditi Shetty from World Youth for Climate Justice, and I will speak in English. I will elaborate on 2 points. First, the intertemporal dimension of climate change and integration of intergenerational equity to achieve climate justice. Second, strengthening the preventive obligations of state to ensure a holistic and inclusive reading of the Inter-American jurisprudence in the context of climate change. The principle of intergenerational equity is at the heart of children, youth, and future generations centered approach to climate change, adaptation, and mitigation policies. This Honorable Court has given extensive recognition in La Oroya cases, and this not only marks the influence of the principle, but also the temporal dimension of climate change.
I'm sorry, please pause because we have a traduction problem. Can you wait, please? 2 of the judges are not listening to the translators.
Could you please just slow down? Could you please slow down? Just that's all that was requested of you, ma'am. Thank you.
Problema de comunicación.
Oh, okay. I can hear myself if I put it on. So.
Sure. Sí, eso pasa en todos los periodos. No los prueban los equipos, no nada. Y vienen a esto días antes, no prueban los equipos. ¿Estás escuchando en español?
From climate change. In other recent cases, that is the Clima Senior, the European Court tactically identified the positive duties of state to tackle proportional intergenerational burden sharing. The court recognized that it is necessary to avoid a disproportionate burden on future generations. Moreover, in the recent concurring opinion of La Orea, it was noted that the principle of intergenerational equity is not isolated. The content of the right to environment cannot be reduced to reparation measures or policies adapted from that perspective. Under that logic, they will only have an impact on a short period, and therefore impacting a group of people in one generation. On the contrary, measures adopted from an environmental perspective must not lose sight of the fact that safeguarding the environmental goods will be inevitable and have an impact on generations in the short as well as the long term. Therefore, we respectfully submit that it is pertinent for the court to include the concept of intergenerational equity in its corpus juris, as it is essential to protecting not only children's rights but also protection of future generations in light of this climate emergency. Owing to the above, we also respectfully invite the court to consider the clear future-facing or intertemporal dimension of climate change, which is inherent in the protection of Article 19 of the Convention. And for this reason, states have a reinforced duty to protect children and future generations. Considering the serious challenges of the climate emergency, the burden will be inherited by the youngest amongst us, and therefore states must duly account for future harms that children, future generation, and youth will suffer. In this light, we respectfully submit to the court that the principle of intergenerational equity should also be systemically integrated and harmoniously interpreted with the relevant articles of the American Convention. In this advisory opinion, we again respectfully invite the court to identify the obligations that stem from an intergenerational reading of Article 26, 19, 4, and 5 of the American Convention in light of this intertemporal nature of the crisis. This honorable court has operationalized some of these aspects in the indigenous communities case, Sumo vs. Nicaragua, and in terms of indigenous communities and their relation to land, and are not merely a matter of possession and production, but a material and spiritual element which they must fully enjoy, even to preserve their cultural legacy and transmit to future generations. Therefore, we contend that states have heightened and differentiated responsibilities within their positive obligations to protect these vulnerable groups from the adverse impacts of climate change and environmental degradation, and by that extension to have positive obligations towards future generations to effectively ensure that the world that they enter in is not in a catastrophe. Coming to my second point, which is also my last point, and moving on to the positive obligations of the states, the foreseeable harm due to climate change, which is irreversible, making this a climate change emergency, engenders a broad base of obligations which states must strive to mitigate, adapt, and hopefully even eliminate. This honorable court in AO 23 and the La Cajonet case has expressly pronounced itself on the right to a healthy environment in both its individual and collective dimensions. Importantly, owed to both present and future generations, which is connected to other rights and fundamental existence of humankind, thus expanding the interpretation of Article 4 and 5 of the American Convention in the context of environmental degradation. In AO 23, this court has observed the principle of prevention in the context of protection of human rights. It was noted that if it is not possible to restore the situation that existed before environmental damage occurred, prevention should be the main policy as regards to environmental protection. Coming back and relying on the concurring opinion in La Ore again, the court has established that the human right to a healthy environment has been understood as a right with both individual and collective connotations. In its collective dimension, the right to a healthy environment constitutes a universal interest owed to both present and future generations. And to conclude here, and in the interest of time, I recognize we submit...
Perdón, ya ha terminado su tiempo, tiene un minuto para...
You're out of time. All you have is 1 minute left.
To conclude here, we submit that states, in their preventive obligations, have a duty to ensure the protection of future generations from adverse impacts, and children and youth, being temporally closest to the adverse impacts, have a right to a healthy environment in the context of anthropogenic climate change. Strengthening this clarification of these positive obligations by taking preventing measures could help achieve climate justice. Thank you.
Muchas gracias al World Youth for Climate Justice.
Okay.
Thank you, World Youth for Climate Justice. I will now recognize the Caribbean Environmental Law Unit of the Faculty of Law at Cave Hill, One Ocean Hub, Renew TT, GNHRE, Caribbean Region, and ILA Caribbean Branch. You have the floor.
Good morning, Madam President, judges of this honorable court. My name is Alana Lancaster, and it is my pleasure to make this intervention on behalf of the amici representing the Caribbean Environmental Law Unit of the Faculty of Law at the University of the West Indies Cave Hill campus, the One Ocean Hub, Renew TT, the Global Network for Human Rights and the Environment Caribbean Region, and the International Law Association Caribbean Branch. Today, the primary focus of our intervention will be on the unique circumstances of the small island developing states in the Latin America and Caribbean region, and the contribution that this honorable court can make to clarifying specific human rights standards for the conduct of states, both individually and collectively, which take into account the increased vulnerability of states posed by the climate emergency. The amici go to great pains to underscore that these states are experiencing the hardest, longest, and most disproportionate impacts of the climate emergency. Secondly, we will make some contributions with respect to human rights and the role the ocean plays in climate mitigation, a process known as the Ocean Climate Nexus. This is of particular importance as the vast majority of Caribbean SIDS are ocean-rich in nature. On average, the ocean under their control is 28 times their land mass. Caribbean SIDS are essentially large ocean states. To put this into perspective, the state of Barbados, where we are currently located, has an exclusive economic zone 388 times its land size, while Antigua and Barbuda's EEZ is 250 times its land size. The marine environment, including continental shelves and exclusive economic zones, therefore comprise the lion's share of the natural resource capital of SIDS. This latter point leads to the third and final focus of our intervention. That is the importance of the ocean to marginalized demographics and the principle of intergenerational equity for Latin America and the Caribbean in general. The region currently has the largest number of children and young people in the history of the region. Yet, the amici note that there are increase in documented instances of human rights violations of frontline and coastal communities, defenders, women, indigenous and Afro-descendant peoples. Many of these impacts arise from climate responses which negatively impact marine ecosystems and biodiversity, as highlighted throughout our submission. Your Excellencies, there are 16 small island developing states in the Latin American region and Caribbean region, stretching from Bahamas in the north to Suriname in the southeast. SIDS will meet in just over a month to discuss and endorse the Antigua and Barbuda agenda for SIDS, which specifically emphasizes the ocean as critical to promoting sustainable ocean-based economies with the help of the international community. While the legal obligations that arise at the Ocean Climate Nexus are already under examination by the International Tribunal by the Law of the Sea, there is still scope for this court to clarify human rights standards with respect to connections between land and sea in the context of climate change. To this end, the court can further develop a harmonious interpretation of the law of the sea and international biodiversity law, together with international climate law and human rights law. Madam President, honorable justices, the human right environment includes a healthy ocean, which, as illustrated by the Barbadian delegation, is essential for SIDS. This includes the role of the ocean in the protection of the human right to culture, children's human right to play, everyone's right to food, as outlined by Oxfam in their intervention, and the rights to life, health, and livelihoods. Importantly, this court's advisory opinion will allow for further clarification of the content and obligations arising from the human right to a healthy environment, already recognized as an autonomous right by this court in advisory opinion 2317, when addressing the threats to the marine environment of the wider Caribbean region. Excellencies, I also wish to underscore the necessity for alignment between both physical and biodiversity sciences, which illustrates the interdependence and interconnectivity between the climate system and the ocean, and the benefits of a healthy ocean to human well-being. This is another noteworthy feature of the Antigua and Barbuda agenda, and is critical for SIDS because their size and geographic characteristics make them integrated land-sea systems, which require collective management as a single unit under the concept of the rich-to-reef approach. This approach is important for comprehensive and effective management of the triple planetary crisis for all states in the wider Caribbean region. But given their sizes and distinct characteristics, is of particular relevance for Latin America and the Caribbean 16 SIDS. This is because threats both on the landward and seaward sides of the coastal margins are concentrated. The amici have noted with satisfaction the court's endorsement of the rich-to-reef approach in advisory opinion 2317, and are pleased to highlight examples of state practice in consonance with the Paris Agreement's national determined contributions by Barbados in their Roof to Reefs program, as well as by other states in the Eastern Caribbean. Apart from their outstanding marine resources, Latin America and the Caribbean also possesses diverse coastal marine environments, known as blue and teal carbon ecosystems. Recognized since 2006 by the Intergovernmental Panel on Climate Change as important carbon sinks, these areas mediate interactions between land, sea, and estuarine systems. Blue and teal carbon are critical components of nature-based solutions and are increasingly important to both climate and biodiversity regimes. Additionally, they host ecological and ecosystemic functions linked to enhanced fisheries, other marine resources, coastal tourism, aquaculture and mariculture, which are all fundamental to Latin America and the Caribbean region. Notably, these ecosystems are also the basis of debt for nature regimes, which are currently underway in Barbados and Belize, and debt for climate regime as proposed by the Barbados, and support both the global biodiversity framework and Paris targets, while also providing a basis for more just and equitable approaches to ocean governance. As our slide summarizes, we have developed more detailed legal interpretations of state obligations in our written intervention on the basis of the arguments I have just outlined. Against this background, the amici wish to highlight these key points for the court's consideration: the need for systemic and evolutive interpretation of the applicable international law, which are supportive of human rights and the ocean climate nexus within the Inter-American region, as outlined in paragraph 25 of our submission. Secondly, the need to assess and prevent extraterritorial human rights impacts of climate measures on children and vulnerable people. This can be done by considering the lessons learned on human rights violations under the REDD Plus process, and is critical to avoiding a repetition of past mistakes within ocean-based climate solutions. The inclusion of the precautionary approach and an ecosystem approach as encapsulated within the Rich-to-Reef approach, thereby supporting the indivisibility of human rights and nature, as argued during day 2 of these hearings. The incorporation of human rights in the design, implementation, financing, monitoring, and review of climate policies, plans, and actions, including the just transition. The latter is a critical aspect of both the ongoing negotiations on the international plastics instrument and the plastics regime, and is emphasized in the Antigua and Barbuda agenda for the blue economy. Finally, a further application of inter-American principles on the climate emergency and human rights, which are mutually supported by international biodiversity law, the law of the sea, and general international law on human rights, with particular attention on the latest clarification of the international law on the rights of the child in General Comment 26 on children's rights of the environment. We thank your excellencies and welcome any questions or comments on your submission. Gracias.
Muchas gracias por su participación y aportes a esta audiencia.
Thank you for your participation in this hearing, and I give the floor to the representation of Elisa Fornal, Veronica Vilkova, Lawrence Burgog Larsens, Federica Cristani, Sara Devido, Curtis Döbler, and Anne Hertogen.
Distinguished members of the court, my name is Elisa Fornal. I'm a professor at the University of Bern, and I'm really honored to appear before you for the oral pleading on behalf of our group of experts in this historic advisory proceeding. In an attempt to assist you in answering the momentous question before you, my aim is to focus on the role of international cooperation to address some of the protection challenges that concern in particular the impact of slow onset event. To this end, I will organize my oral pleading as follows. First, I will introduce a little bit how slow onset events affect access to human rights. And second, I will discuss how cooperative duty should be strengthened to ensure the protection of affected population in the short, medium, and long term. It is widely agreed that the cooperative duties are requested to comply with international human rights norms. Madam President, distinguished members of the court, I will now move on to the first part of my pleading, highlighting that slow onset events are long-term processes during which human rights are critically affected at different time points. As is illustrated by several UN special procedures, the reality is that slow onset events interfere with the ability of affected population to access and benefit for the human rights. And just to give you some example, in the last year, for instance, we have found that there are implications for economic social rights, cultural rights, participatory rights, family and private life. And this creates unprecedented protection gaps. So exposure to slow onset event not only increase people vulnerability, but also increase the risk of exploitation. And we have seen also some cases at domestic level, for instance, that we have documented cases of trafficking and exploitation, new forms of modern slavery, in particular for people who are first to move. This means that affected populations are increasingly exposed to what some scholars refer as slow violence, namely a violence that occurs gradually and postpones the structural power over space and time, and this in turn contributes to multiple intersecting inequalities. Here we face three challenges. Firstly, the use of a wide margin of appreciation by state to intervene to protect individuals under their jurisdiction. And this point has been in part addressed also by the most recent historic case, the Clima Signorina, by the European Court of Human Rights. And the court in this case confirmed the pressing need to ensure that the legal protection of human rights should be given priority when balancing between different, even competing interests. And second, and linking to this previous point, I would like also to refer to the issue that has been addressed yesterday, in particular yesterday afternoon, about the use of temporal notion, such as crisis or emergency, because this notion could also be used by state to justify limitation on human rights. However, human rights derogation, even if permitted, must be non-discriminatory, as well proportional, and in place for the shorter periods of time. As argued by Judge Charles Worth more than 20 years ago, the crisis model has a risk because these divert attention from providing long-term solutions focused on tackling the global and structural injustice that in our case are linked to environmental degradation. Third, this also could have an impact on the co-distribution of human rights duties among member states, because these reflect the discrepancies that we are seeing between what are perceived as the legal duties of the state that are not directly or less affected by climate change. So what is important to remind is that the ability of affected state to meet the human rights obligation needs to be maintained. To conclude my first point, this means that the distribution of obligation between states and the international community needs to be adjusted to the need of the most vulnerable population without compromising the stability on which international law depends. Now I will, Madam President and distinguished members of the court, I would like to move to the second point of my presentation, where I will stress the role of international cooperation in the context of law-set event. Before that, allow me briefly to recall that the general obligation to cooperate is drawn generally from Article 1, Paragraph 3, 55 and 56 of the United Charter. And international cooperation really plays a central role in fostering interstate relations and stability. The centrality of international cooperation in the UN frameworks confirms that there is a general duty for states to engage with each other. International cooperation was also among the issues that received the widest support during the debate at the UN SIS committee in front of the General Assembly related to the topic of sea level rise and international law. So this principle we know is grounded in binding treaty obligation, but it has also been interpreted by international court and tribunal, and I remember very briefly, I recall also this court in its advisory opinion in 2017 concluded that the states have the obligation to cooperate in good faith to protect against environmental damage. This required to notify, consult, and negotiate in good faith. But I would like to stress in particular the last point, because cooperation between states could require to adopt new and legal and institutional framework through which cooperation could be achieved by contributing to the progress of human rights. International cooperation is commonly included in human rights treaties. Some instruments refer simply to a duty of international assistance and cooperation, but others also include in their definition the duty to seek to conclude agreement with other states for the fulfillment of their human rights obligation. So this is becoming increasingly critical, in particular, and I would like to focus a little bit more on the challenges that we are facing to translate human rights obligation in the context of climate migration in the short and long term. Because as highlighted by the Sydney Declaration, the duty to cooperate requires states also to improve their effort to strengthen a coordinated measure that guarantee human mobility options at domestic, sub-regional, regional, and international level, which should be predictable and durable. In this context, to make cooperative duties effective over the long term, states are required to develop human rights-based and gender-responsive bilateral regional agreement in the context of cross-border migration. Finally, to conclude my second point on the role of international cooperation, I will focus very briefly on the role of what we think is also emerging as critical, the role of interstitial norms and principles as defined by law for the protection of the environment and prevention of climate change. Because we believe that the interstitial norms also can play an active role when not only for interpreting international obligation, but also in trying to see how international obligation fit together. Because beyond setting out cooperative duties, it will be necessary to address the fact that the state will be faced with conflicting or competing obligation. For instance, we have seen in the context between economic development and the protection of the environment. So if we focus on climate migration, let me just briefly recall the emergence of the role of principle of good neighborliness, that these could also be used to support international cooperation by taking into consideration the geographical proximity between affected and less affected states. So this will allow protection to be met and also to facilitate human mobility between neighboring states, but at the same time to prevent what is emerging as an issue of concern, and some scholars identify as the implementation of a so-called self-deportation strategy, which constitute a modern removal strategy of making migrant lives so unbearable that they will leave the country. So to conclude, I would like just to identify the following prominent issue that we suggested that the court could take under consideration in this advisory opinion for protecting the right of affected population. Recognize international cooperation as a legal obligation that applies to the obligation of the American Convention on Human Rights. Recognize the need for states to assume regulatory responsibility. And finally, to recognize also the role of interstitial norms to guide the state to overcome possible potential conflicts that could affect the primary responsibility to respect, protect, and fulfill the rights of affected population. Madam President, distinguished judges, this brings my submission to a close, and I would like to express my gratitude for your attention.
Muchísimas gracias por sus aportes a esta audiencia.
Thank you for your participation. Now we will go into the question and answer period for our colleagues. Judge Patricia Perez Goldberg, do you have any questions? Yes, Madam President. Thank you for your presentations. They were very clear and very comprehensive. In the interest of time, I have only 2 questions. First of all, for Youth for Climate Justice. I'd like to ask you to elaborate on the pending advisory opinion on climate change that was requested to the International Court of Justice, and one of the points that was part of that request was that it elaborates on whether states have legal obligations based on the principle of intergenerational justice. What do you think this court has to add, or that is different, or that supplements that advisory opinion? That's my first question.
Judge, if I may in English, the current advisory opinion before the ICJ, as you rightly mentioned, it's intergenerational justice is one of the aspects of many obligations that are requested to be clarified. In terms of what can be added, as I mentioned previously in my submission, that it is well recognized, the principle is well recognized by this court, by international courts, or also by a lot of domestic courts around the world. However, there is some disconnect for it to be part of jus cogens, and then going into how to apply it within obligations. So that's the reason one of my submission was looking into the preventive obligations of states, because they can have positive as well as negative obligations. So the positive obligations in itself would say that because of the precautionary principle, because of sustainable development, because of preventive measures that states need to take, within that, I think there could be an addition through that clarification and an explicit analysis or an explicit analysis by this court would be like a stepping stone to that. Not only that advisory opinion, I think other regional domestic, other regional courts and also domestic litigation cases if they come into the future.
Thank you very much. Una segunda pregunta a la
I have another question for Professor Lancaster. I'd like for you to elaborate on the following. You talked about the supplementary nature of contribution, similarly to this question, as to what we could contribute to supplement the advisory opinion pending before the International Tribunal for the Law of the Sea. I'd like for you to elaborate on that specific consideration you made about the key issue of subsistence for SIDS, and how this court could add to that or do something different from that advisory opinion that is still pending before that tribunal.
Thank you. First of all, I think that the basis of the court's advisory opinion as coming from a human rights perspective will, by that very nature, add to an advisory opinion which will be primarily through the lens of Part 12 of the Law of the Sea Convention with respect to the climate change. And to some extent, that opinion will be, I don't want to say limited, but within that scope. One of the things that this court can offer, and they have already identified the principles, is linking the importance of the right to a healthy environment with many of the rights under the Protocol of San Salvador, for example, some of which have already been espoused by the Human Rights Committee, for example, in the Torres Straits Islanders. But within the Protocol of San Salvador, I think there's a more fundamental basis. It will also align with previous as well as more recent jurisprudence of the court. And one of the things that we note is that the relationship between human rights and the marine or coastal environment is not as strong in the marine environment as is in the coastal environment. And I think the courts in both advisory opinion 23 as well as recent Laurel, for instance, as well as the mosquito divers case, have developed a set of principles as well as a clear direction in that the marine environment is as important, if not more important, for states such as especially the small island development states, who really and truly this is their main annuity, if you want to say it, in the future. Thank you.
Thank you very much. No tengo más preguntas.
Thank you. I have no further questions.
Thank you. Judge Gomez. Yes. I will begin with the end.
So, Professor Fornal, thank you very much for the intervention. On behalf of such a prestigious group of scholars, what caught my attention is you devoted a lot of time of your intervention on the issue of international cooperation and the policies of good neighboring. Do you think that's the approach for the sort of damage that we're talking about? International cooperation, good neighbor? You've been here, you've been listening for the last 2 days. Is that the right approach? I was surprised because you devoted a lot of time of your intervention on that. So,
Thank you a lot. Honored Judge, I would like to elaborate a little bit on the reason why I included this attention on cooperation, because I'm also involved in the work of the International Law Association on sea level rise and international law, and we identify this as an emerging principle that needs to be developed more, because this was also the request from the member state. As I mentioned before, the member state submitted several statements where they ask, for instance, the International Law Commission on sea level rise and international law to clarify the content of the duty to cooperate in relation to the protection of affected population. And why I included the good neighborhood is because we have these new bilateral treaties adopted between Tuvalu and Australia, and they decided to adopt this bilateral agreement under the principle of good neighboring. So I found that maybe this is a principle that was not under the radar in this specific context, but they decided to develop more what they call climate cooperation, to ensure that there are regular pathways for migrants that decide to move from Tuvalu to Australia. So I think that maybe could be a possibility to explore more, because it's true that we tend to focus on the good neighborhood as a principle that requires state to abstain, but maybe we can also see this as a proactive principle to increase cooperation. I think my focus was mainly really related to human mobility in this context.
But you mentioned it also when you were talking about climate migration.
Yeah.
You were talking about good neighboring. Aren't we lowering the standards?
I'm not sure.
Okay. No, it was a question because you were talking about climate migration and to what degree we're confronting forced displacements and people that have to cross borders. No, but I think you've answered on your perspectives. Just call my attention because also the term has been used through history, different contexts. It doesn't have such great press. That's why. All right. But let's move from cooperation and good neighboring, and let's go to responsibility. If there were responsibility, moving from your, paradigm of cooperation and good neighboring, how would you identify victims and establish reparations in cases, for instance, let's talk about sea level rise. We have distinguished delegation from the Caribbean here that are interested in that. So how would you do it?
You mean in case that cooperation is not implemented? In
case in which if you were talking about responsibility, not just cooperation.
I think it's depend. I identify in the moment where, for instance, there is a violation of human rights of affected population, and again, my focus was mainly in the case when people are forced to move. So it depends if this kind of violation occur, for instance, in relation to different kind of duties. It can be the duties to prevent or the duties to protect or to fulfill their human rights. So it depends. When we talk about the people affected by sea level rise, there are different situations in place. So it depends if it will be the state under which they are, under which jurisdiction they are, or if it will be a state in transit that we can identify as a transit state of the country of origin. I think there are different spectrum of options there. For this, I talk also about the issues of distribution of duties and responsibilities, because there are more states that need to be considered in this process. So I think it's the complexity of the issue when we talk about sea level rise is this, from my perspective.
Thank you very much. I have another question for Professor Lancaster Salmon. Thank you very much for appearing and for the Caribbean group. You were very eloquent when you were talking about the need to have harmonious interpretation of different legal don't want to call them systems, but groups of rules. And you mentioned law of the sea, international biodiversity laws, environmental law, and human rights law. It's been a theme. We've been talking about this the last 2 days. But if you could talk a little bit more about this. How do we achieve the objective of harmonious interpretation? We're putting all of these elements together. Especially because nobody has, straight, absolute, clear jurisdiction to apply all of them at the same time. So, yes, that's,
yeah. Thank you. I think one of the starting places with respect to states in the wider Caribbean region is to perhaps tease out these elements in existing obligations which states have. Specifically with respect to the marine environment, I'm thinking of the Cartagena Convention for the wider Caribbean region, which incorporates many of the elements, and because of the nature of the instrument, the scope and objective of the instrument also clearly aligns with, for example, this Convention on Biological Diversity, which has developed an impressive framework, which is in respect to the role of international biodiversity law, the ocean, and human rights, including with indigenous peoples and also Afro-descendant communities. However, and further, I don't think many of what is perhaps the new lens is the human rights lens, because in many respects, states have committed on the various paradigms. So, for example, the Sustainable Development Goals. Most states in the region have endorsed these. They've endorsed the Paris Agreement. The Sustainable Development Goals require the alignment of Sustainable Development Goals 14, 15, and 13, which are climate action, life on land and life on water. And most importantly, there have been linkages with Sustainable Development Goal 16, which is where I see for states to give homage to this, they need to strengthen human rights in various areas across their legal regimes, for example, business and human rights.
Okay, because yesterday some very prestigious jurists had lots of doubts. If you had an object of protection that was marine life or, species other than our species, and they were looking at human rights on the one side and environmental law on the other side, and separate because they have a different object of protection, let's say. But at the same time, to have the entire view, it looks like you're asking for a harmonious interpretation, where we have objects of protection that, in theory, when these rules were approved, were different. But it looks like now we have to consider them together.
Yes, I would say so. I think we are in an era where there's been a substantial paradigm shift, our understanding of the science, both climate science as well as biodiversity science. In addition to, I think when many of the early international law instruments, for example, were developed, they were developed in isolation of the social and basically the economic, social, and cultural aspects. In many respects, in the earlier days of conservation, we were concerned with ecosystems. We were concerned about balancing mainly ecosystems and economics. I think somewhere within that framework, the human element got lost. And it is critical, a lot of what we're here, the climate emergency, oceans, the human element is both the bridge which we're trying to safeguard, but also the person, the entity that is.
Let me see if I understand you. It's very difficult to talk about biodiversity without understanding that our species is also affected by the lack of biodiversity,
Yes,
and therefore should be part of the legal framework.
Yes.
Thank you. Thank you very much for that. La última, señora Presidenta, prometo.
Last question, Madam President, for the association Ruta del Clima, the Climate Route Association. You spoke about reparations. How can how can the pecuniary, non-pecuniary damage be calculated in climate change cases with the types of progressive impact we see, and also the tipping points? We've talked about that. Thank you, Your Honor. With respect to the economic impacts, I think it's much simpler to do. There are methodologies on risk management that are in general use. What we do not have are systems for national monitoring to quantify the figures, for example, in cases of slow movement, slow evolution. There is a serious lack of data. There is also a serious lack of parameters, standardized parameters for monitoring these things. Science exists, it's out there, but the states, and this is part of the historic development of the Framework Convention, this issue simply has not been developed, and so far the states, for example in Panama, they are developing a system for monitoring loss and damage with 16 indicators. So there are countries doing it. With non-economic damage and losses, the states are starting to develop mechanisms to figure it out, but this is something being developed only now. What's missing is demand. The states have not established mechanisms for reparations requiring data of this kind. Good. Since you have these associations have similar names, so maybe you could also answer about in your submission, oral submission, you made reference to the types of funds, the voluntary funds that already exist for reparations. What can be done, even beyond the currently existing funds? You were very emphatic about this. The UNFCCC framework. Is it enough? What paths could be followed? What avenues could be taken to create reparation funds? Initially, I think it would be necessary to ask the states that are most rigorous with these funds. The communities are suffering the impact of the climate crisis, and the way to redress is not through a voluntary fund. The state or the international corporations decide whether or not they want to help with the redress, to repair the damage they caused, or simply not to, or not to help the community. We need to be more demanding. And we need to regulate so that these funds become mandatory and not optional, voluntary. Human rights cannot be violated by the states.
May it please the Court, Nikki Reich with the Center for International Environmental Law. Just to add to a few points with regard to the Loss and Damage Fund that's been established just at COP28 under the UNFCCC. A few initial remarks about the inadequacy of the fund, and then in fact it hasn't actually been set up to provide reparations at all, and would not result in the required support and redress needed, which goes far beyond monetary considerations, even if it were adequately funded, which it hasn't been yet. There is no reference to human rights at all in the substantive provisions of the fund, only a reference in the preamble. And there's also extremely limited participation on the part of Indigenous peoples, communities affected. They are not part of the board of this fund, and they have very limited access to and participation, as we've recently witnessed in a first meeting. There's also no mention of common but differentiated responsibilities, and there has been a consistent and concerted attempt in the language regarding that fund to de-link it from the basis for legal responsibility, echoing what we've seen before in the negotiations and attempts in the adoption of the Paris Agreement to include language that suggests it provides no basis for compensation or reparation. But that underscores really the importance and opportunity that this honorable court has to reinforce the very clear and strong basis in law for the right to remedy and reparation in the face of evident, manifest and mounting damages and violations of long-standing and pre-existing legal obligations to prevent transboundary harm and to protect human rights. And that the law is indeed clear, as my colleague said, that both under conventional and customary law, under the American Convention, as this honorable court has said, when there is a breach of an international obligation that has caused damage, that entails a duty to make full reparation.
We understand that.
Yes.
If the fund doesn't consider common and differentiated responsibilities, if human rights is not a parameter, and if there is no participation of afflicted communities, what does it do? What does it do? What does it cover?
Respectfully, Your Honor, I think in many ways the jury is out on whether it will and what it will cover. And I will turn to my colleague to complete and come back, if possible, with the court's permission.
Señora jueza, el fondo
Your Honor, the fund mainly handles the financing gaps for loss and damages. It provides financing for loans and grants. But most of the issue of loss and damage is not covered by the fund. Instead, financing mechanisms cover it. And these are international banking entities that need to provide funding by means of loans and other mechanisms. This is why we have warned that when victims become consumers of financial services, because that's the main structure of this fund for loss and damage, and the financial mechanism, which is the substantive part of what was created in COP27 and COP28.
If I may, just to add as well that, as my colleague has alluded, and as this honorable court's jurisprudence recognizes, that reparation takes many different forms and encompasses critically beyond just compensation, guarantees of non-recurrence, and there's as well as other forms of restitution. And the fund that's been created does not address those full dimensions of what reparation requires and entails. But in fact, as we've heard throughout the hearings to date, the conduct that is within the control and jurisdiction of states can and should be regulated and affected to prevent recurrence, including one of the best ways to ensure non-recurrence is to phase out fossil fuels and other conduct that is driving a loss and damage.
Understood. We're just talking about the fund. Thank you. Thank you very much.
Gracias, jueza Gómez.
Thank you.
Thank you, Judge Gomez. Judge Perez Manrique, do you have questions? Yes. Along the same lines, about the fund. The second group of speakers, where you also have La Ruta del Clima. In their written submissions, you refer to the fact that the way the fund is constructed or constituted might contribute to structural violence in our countries. If you could please elaborate, what are the risks? You have somehow already alluded to this, but if you could please give more detail, how this fund as it is constituted might become a factor for an increase in structural violence in the region. Thank you. Thank you very much, Judge. One of the main objectives or mechanisms the fund has it can provide non-reimbursable funds, but the real approach is as loans, insurances, and other financial mechanisms. Separately, when you have the fund and you have the financing mechanisms. The mandate under Article 8 is relegated to the financing mechanism. So when we see there's a vulnerable community such as Puerto Rico, Costa Rica, where you already have risk indices created related to people's credit ratings or records, the exposure you have to climate risk makes you more vulnerable. Depending on where you live, it affects your credit rating. So in terms of access to financing and to be able to move around, it's important to consider. And then Latin America is one of the regions that is most indebted, and those suffering most are, again, vulnerable communities. And in this case, it's just a transfer. The common but differentiated responsibilities are not assumed by the large emitters. It's actually taken on by the countries and the main affected. So they have to bear the cost of getting insurance, taking out a loan to be able to face the loss and damages, whether through local governments or an emergency committee, or directly themselves. And that is the game that will lead to more violence and more inequality, because we're adding pressure to the economic game we already have to play in our communities. So then you hold that the fund has one single way of contribution, which is financing, and financing comes at a cost. Indeed, financing, first of all, is provided by donors, and generally these are developed countries. Although these can be non-reimbursable funds, it is designed for it to be used by financial institutions such as the World Bank, the Inter-American Bank, who have the purpose of loaning money or creating mechanisms, bonds, or financial services in the end. And that's not the logic of a person that has suffered a violation of human rights because of cross-boundary damage. It's not the duty of that person to get insured or take out a loan. It should be by the state. And that's the logic we are seeing in this fund. And obviously there's no obligation to even provide any type of funding to the fund, or even the financial institutions that also depend on financing that, again, is decided by developed countries, such as the World Bank. Could you be more specific within this regime and how the fund would work, how that would lead to more structural violence? It would be because of the activity of the fund and how it's deployed?
And thank you for the question. One of the fundamental ways that the fund, as it is currently constructed, risks reinforcing structural violence is that in its failure and explicit attempt to de-link funding from legal obligation, it risks blocking access to justice. And it cannot and should not be used as an excuse to prevent communities and individuals affected from accessing justice at the national level or the regional level, or otherwise seeking to hold states accountable to their legal responsibilities. Indeed, it cannot and should not be used as an excuse for states in this region not to demand what is legally owed under international law. And it's also critical that the lack of participation on the part of affected peoples and communities in the fund restricts in its ability to respond to the various types of material and non-material harm that is being caused by climate change. This goes to the question around calculation. I think it is critical that people victims of climate harm are self-identifying and are able to describe what needs to be repaired. And there is a lack of access and ability to do that in the fund as it is currently constructed. But that is also why it is such an opportunity for this court to reinforce that nothing about this mechanism displaces the existing obligation under human rights law and longstanding law of state responsibility and international environmental law, and the clear duties to provide reparation when states have, through their acts and omissions over time, contributed to evident climate harm. It also, just on the financing issue, that there is, whether or not this fund exists, the right to reparation and remedy exists under law and persists alongside this and needs to take many forms. And currently, the levels of financing that have been committed are nowhere near at the scale of the mounting loss and damage being witnessed around the world. I believe my colleague wanted to add something.
Nada más 10 segundos. La razón de por qué existe.
The reason why the fund exists is because there's a textual statement saying that talking about the non-responsibility of loss and damages. This is this decision of COP21, and so that alternative created is where you have structural violence. It was a decision of states in interpreting the Paris Agreement with a non-binding decision because it expressly does not want to create a reparation mechanism. It is stated explicitly so in the Paris Agreement. And so this is the alternative solution that has been created because of that political decision. Thank you very much. You've given good examples of how to relate the situation of the fund and structural violence. Thank you. I would now like to ask World Youth. You've given a clear presentation as to what future generations are concerned about. And when we talk about future generations, it's children, young people, up to a certain age. So the question is, there's another dimension of future generations, the people yet to be born, people that are not here today in the planet. And even before being born, they are already affected by this phenomenon. So I'd like to hear your thoughts on that. Thank you for the question, Your Honor. We would like to make a distinction between the concepts developed by the court in terms of the people yet to be born and future generations. We believe that future generations as a concept are objects to rights. They are right bearers. So present generations, particularly states, have the duty to protect the future rights they will have once they are here. Very specifically, I'd like to highlight this court's opinion or criterion on the connection of the rights of the child, as we also mentioned during our submission, youth, with future generations. Because by protecting the rights of children and youth, we are protecting the rights of future generations, trying to preserve the same quality of planet and natural resources and cultural resources that we have today. Thank you. So let's talk about the future generations as you have conceptualized. What are the main issues and what could the court contribute to in terms of standards? Thinking about participation of future generations. We know there's the issue of representation, of determining harm or damage, to be able to demand protection, etc. But I'd like to know your thoughts, please.
Thank you for the question. As for, just to repeat it so that I know I've understood it correctly, is that what you asked, what standards need to be observed, right?
Respecto de la participación.
Regarding the participation of future generations, the right to participate.
As my colleague mentioned earlier, children and youth are the nearest to understanding how climate change will affect them. And that's the reason why youth and children have a better or sort of a foreseeable understanding of how this would affect. She said that, she also mentioned that the date of their birth will then determine how much they're going to be affected. So just in that sense, I think allowing youth and children to have that standing for them would be one of the standards. And just to mention, and just to go a little bit further into that, I think in the case of Opusa versus Factorin, the Filipino Supreme Court actually lowered that and allowed minors to talk in the interest of future generations. So that perhaps could be one of the standards. However, within the obligation of preventing and within the positive obligations, states could also enable certain measures that have a forward-looking climate policy, climate environmental policy, in a way of ensuring that the interests of future generations are protected. And I hope that answers your question, and I'll pass it on to my colleague.
Just to add to that, and thank you for the question, Article 19, I think, also contemplates participation of children in matters that affect them. I think there is nothing that affects them most than the climate emergency. So in this sense, there's no need for material damages to exist already for children to request or participate on behalf of future generations for states to take action to guarantee and respect the future rights of future generations. Thank you very much. To Caribbean environment. First, in your observations, you have in paragraph 87 referred to the fact that it is necessary for states, or that states could design effective programs to integrate environmental democracy in the pursuit of stronger children or strengthening children's rights. So could you please elaborate?
Sorry, just give me a moment to confer.
Lo tengo marcado como párrafo 80.
I have it under paragraph 87.
I will ask my colleague to expound on this.
Good morning, honorable judges. My name is Elisa Morgera. I'm the director of the One Ocean Hub, and I've worked with colleagues at the University of West Indies for 5 years on these questions. I think our arguments on intergenerational equity very much build on what our colleagues have mentioned around the importance of existing legally binding obligation on children's rights, and also building on specific regional instruments such as the Cartagena Convention and the Esquazú Agreement. And I think there are 2 points here to keep in mind. I mean, one is even clearer indications around the interpretation of children's participation in any processes that may affect their rights, which have been illustrated in the general comment, number 26. But additionally, I think that point that's mentioned in paragraph 87 around distributive effects can lead to another consideration in terms of participation and representation of children's rights and, in fact, future generations. And that has to do with the temporal element and the science we can rely upon to understand what those distributive effects might be. The Convention on the Rights of the Child is very clear that states have obligation to consider impacts on the life course of children, and that really means multiple decades, 50 and more. And we have science showing us now what are the vulnerabilities of children, and particularly how those vulnerabilities clarify state obligations in terms of protecting children's rights to life, survival, and development. And I think children's right to development and its interaction with children's health and children's cultures can provide a crucial element in identifying both relevant either medical or other scientific evidence that can clarify today what those distributive effects might be, and then shed light on the obligations of states, but also institutions where those decisions are being taken to consider that science and engage children in understanding what that science means to them and to their own perspectives of life and their agency in co-shaping the future solutions and immediate solutions to climate change.
I understand your explanation perfectly. The question is what standards would help us truly bring into effect this democracy and strengthen, as you've said in your amicus, the participation of children.
Two substantive rights. One is children's rights to be heard, which has both procedural and substantive obligations for states. And the second is children's rights to development, which really provides the understanding of temporal vulnerability and extends, I think what we suggested in our written intervention, it can really shape the understanding of prevention and precaution in terms of vulnerabilities, time spans, and legal standards of protection.
Bien.
Thank you.
Finally, I listened with great interest to all submissions. And in the case of the presentation by Elisa Fornal, I have taken a few notes, and according to my notes, in your presentation, you employed a principle that I would like you to elaborate upon. You referred to the principle of indubio pro futures generationibus, meaning pro in favor. When in doubt, the law should be interpreted according to the rights of future generations. That's how I see it. But I would like for you to elaborate on that, because it will be important for the court. It's an important concept that you are bringing forth and developing yourselves.
Yeah, this is a little bit a suggestion that we try to elaborate, because we realize the increasing role that the principle pro natura is playing, in particular in the context of Latin America, and we wanted to try to see if we can expand a little bit the impact of this principle, bringing into the context also the role of intergenerational equity. So we wanted to understand if the protection of nature could also mean that these, together with the precautionary principle, could include also ensures that we can protect the present and future generation. So we suggested to go a little bit further, not only to focus on the pro natura that has mainly this role also as an interpretative tool to favor the protection of the environment, including human and non-human. But in our elaboration, we would like to take a step further to include also this intertemporal dimension. So for this, we suggested to shift the brocardo from pro natura to pro futuribus generationibus. So this is really a suggestion that we wanted to bring to your attention.
Well, I have taken note of it, at least. And could you please explain how it would work? How do you envision it working? Because you came with a proposal, so we would like to see
that there is, even if we don't have any scientific certainty that there will be the risk of an irreparable effect, damages, in any case, we need to protect the environment with the interest that the protection of the environment now will include the present and future generations. So this is also in this view to include also generations that are both human and non-human. So this is condensate a little bit the development we have been with together the pro natura and the intergenerational equity principle. So I read also in the concurring opinion that this was a little bit the approach that was suggested also in the Peru case. So our suggestion goes in line, but we rephrase that as a pro futuribus generationibus. Again, with the idea to solve possible issues of interpretation, again, in the absence of certainty, for instance, from the scientific perspective. So taking a precautionary approach in this context.
Thank you so much. Thank you for all your answers. You have been very kind. I have no further questions, Madam President. Thank you. Judge Ferrer MacGregor, do you have any questions? Thank you, Madam President. First of all, thank you so much for your very valuable submissions, both in writing and oral, that will lead to a great deal of reflection on our part. There's something that is a matter of concern to me. This is day 3, so I was wondering how many days it's been. It feels like a week, but it's been only 3 days. Very intense days, by the way, but there's something that I'm concerned about. That has to do with something important, which has to do with a general principle. The general principle of shared but differentiated responsibilities, CBDR. So how can we make this materialize in practice? How can we get there? That's the question. Voluntary funds are insufficient. You have spoken of several things. Each of you has raised several issues, and we've heard several points of views. But what I would like to hear is from each delegation, for a maximum of 2 minutes, if I may, and speak slowly, please, for the interpreters to be able to follow you. For a maximum of 2 minutes, please tell us, from your point of view, how we can help this principle materialize. How do we bring it down to earth, this principle of shared but differentiated responsibilities, common but differentiated responsibilities? How is this principle lived in practice? You know, there's the issue of intergenerational equity, common but differentiated responsibilities, and international cooperation, of course, which was raised here as well. And then national capabilities, and the need to protect and guarantee human rights. So all countries have said that they're under the obligation to protect rights. They must all contribute to climate action, but not all of them have contributed in the same way to the climate emergency or have the same needs and the same resources to respond. So how can we actually make this materialize and become a reality? I would like to hear from all delegations about that. Of course, we have a limited amount of time, but in 2 minutes, tops, in the same order that you spoke. Thank you, Your Honor. I think that evidently there is a report by Oxfam about cumulative historical emissions, where it says that developed countries, according to the Framework Convention or the Global North, is responsible for 90 to 92% cumulative emissions along history. So that's there's the reality. There are different responsibilities. When we talk about the reduction targets, which also entails reducing damage, not all countries necessarily, and this is seen in the Universidad Politécnica de Catalunya study, where they speak of equity and carbon budget. We are under the obligation to reduce emissions, but that obligation does not is not incumbent upon us in the same way. So, and that has to do with the actions. I mean, these are economic actions, actions by persons, by countries as defined by the Framework Convention. So the first step to have a good allocation of responsibilities is, first of all, to recognize what the legal responsibilities are for each case. And that's eliminated by paragraph 51. And all of those states, even those under the American Convention, all those signatory countries have decided to accept, first of all, accept and take responsibility, and also, secondly, based on your actions. Panama, Costa Rica have less than 0.005% of global emissions. I mean, so that's how it is for Central American and Caribbean countries. So that can be ascertained in figures. And there are university papers about that can help us allocate responsibility so that we can find a way to repair climate change.
Thank you very much, Judge, for the question. I think this is a critical, the question really critically underscores the opportunity that this court has to clarify that longstanding human rights law, including the principles of equity and maximum available resources or progressive realization, those concepts can be brought to bear to complement and complete and reinforce the concept of common but differentiated responsibilities and respective capabilities under international environmental law and the climate agreements. And that the differential responsibility of developed states that have generated the lion's share of cumulative emissions and have greater capabilities to respond and redress harms is reflected in and flows from those legal obligations. Just as under human rights law, states' obligations are differentiated according to their resources and capacity alongside their proportional contributions to a given harm or human rights violation, so too can and should it be with regard to climate harm. And that those differential contributions to the harm through cumulative acts and omissions over time and differential capacities to respond can help distinguish the obligations incumbent chiefly upon the developed states to provide not only reparation for loss and damage, but the various forms of reparation needed, including not just compensation and finance, but also technology transfer and guarantees of non-recurrence, and that those responsibilities encompass and not only all three pillars of climate action: mitigation, adaptation, and loss and damage. But I think that there is a clear role here for the long-standing jurisprudence on equity and maximum available resources to help concretize what that CBDR means in practice here. And the last thing I would just say is that with regard to many of the questions about implementation of the principle of intergenerational equity The Maastricht Principles on the Human Rights of Future Generations contain a number of very helpful elaborations of what it would mean in practice, for example, to apply the precautionary principle with a mind towards the rights of future generations, such that, as it says, and I quote from Principle 9, the burden of proof in all circumstances must lie with those who would undertake or persist in the conduct involved, not with those who might be harmed. And I think this court, in drawing on its own jurisprudence and that in other international environmental law cases, could operationalize that burden shifting in cases where harm and responsibility is at issue, and that would go a long way towards addressing the rights of future generations facing irreparable threats. To complete me very briefly, yeah, go ahead, please, sorry.
Procurar que sea.
Okay.
Please be brief. In fact, everything she talked about pretty much summarizes how we would see the responsibility of the countries. I would simply add then that if we look at it in terms of climate justice, in order to have justice, there needs to be social justice, environmental justice, and justice overall. We cannot think that the countries would take responsibility without starting with a concept of justice that covers everything. In our submission, we, as countries of the Global South, our emissions, we don't have large industries so much. We do not have so many transnational companies, and therefore our impact in terms of greenhouse gases is minimum. But we are suffering more from these damages and these losses than by those who generate more. So you need to start with the idea of social justice in order to achieve environmental justice or climate justice.
Thank you for the question. As my colleagues already mentioned, this principle, as well as the principle in intergenerational equity, stem from equity itself. And again, to achieve climate justice, again, I'm echoing my colleagues' words here because I think we stand on similar lines, is that if climate justice needs to be achieved, and if there is a recognition of differentiated responsibilities because climate change is affecting different people, different groups differently, bringing that into the social aspect and the human rights aspect, this principle forms the basis of how certain, not just countries, but certain states and certain states should develop or not develop or allow certain other states to develop. So having that standard, I think in the core with its equity would be crucial to understanding the applications of CBDRRC in the context of the climate emergency. And again, just to echo my colleagues' words here, like the Maastricht Principles, again, embed certain obligations in respect to future generations and their right to be protected. And when they come into the world, again, as mentioned by my colleague earlier, have the right to harmonious development. That can only happen if certain states take certain kind of responsibilities. I think I'll stop there.
Thank you for the question. I think I will first start by saying that we can identify existing examples of best practice. I cite the example of the Convention on Biological Diversity, which can be harmoniously interpreted both with the Inter-American system, both with the instruments in the Inter-American system, as well as with the Cartagena Convention, which guides not only the wider marine environment of the Caribbean region, which touches and concerns most Latin American and Caribbean countries, but also has a component on land-based sources, which outlines very specific standards and that can be interrelated. And I would say the court in its decisions, include both contentious as well as advisory opinions, have teased out linkages between the system and the Convention on Biological Diversity, for example, in the Kalina case, and with the Cartagena Convention in Advisory Opinion 2310. We, in our submission in paragraph 140I, also highlight some guidelines with respect to small island developing states within the Latin American region. And I wouldn't go through all of them. One of the ones I think is critical to highlight is one of the key components of common number differentiated responsibility is transfer of technology and cooperation. And one of the things we underscore is that it is clearly critical and necessary for small island development states as well as Latin American states. But what is needed is technology transfer that is not a mere transfer from the global south to the global north to the global south, but one which incorporates traditional knowledge as well as leads to capacity building. I will end by saying that this is currently under consideration within the context, the same issue of how to best articulate meaningful common but differentiated responsibility is currently under discussion as we speak, I think, yes, with the internationally legal binding instrument on plastic pollution, including in the marine environment, which is of obvious relevance within the context in which we speak. Thank you.
Okay, thank you again for your question, Honor. I would like to conclude by linking the role of the principle of common but differentiated responsibility to the cooperative duties that was the focus of my presentation, because I think, and this is my understanding of when we talk about cooperative duties, specifically in the context of human rights, these I identify as a legal obligation. And once, as I said before, what is crucial, in particular for vulnerable states affected by climate change, and let's take the case of small island states, that they have the possibility to continue to protect the rights of their population. And once they are not more able to meet, for instance, international human rights obligation, and I think in particular socio-economic rights, I think in their context the principle of common but differentiated responsibility could play a role, because external state, less affected state, but also states that have more capacity, will play a role by providing finance, technology transfer, capacity building, also to ensure that the population, for instance, has the possibility to remain in their island. So there is all this component that I see as a legal obligation, and in this context the principle could play a significant role in giving content to the cooperative duties in the context of human rights.
Bueno, aprovechando que
you're talking about a duty for international cooperation, and you associate it with, you link it to what in the text you gave us with Article 26 of the American Convention. Is that correct? That is, from the perspective of the convention, you're saying that there are a number of instruments, right? But you linked it to the American Convention. Could you explain that a little bit?
I wanted to stress a little bit with our intervention. So to see the role of cooperation, international cooperation, as really a legal obligation to ensure the protection of human rights included in the American Convention of Human Rights, that can be derived by the general obligation also included in United Nations Charter. This is, I see that there is some doubt, but I believe that we can also rely on the impact of other instruments. Cooperative duties in the context of human rights means also to provide support to affected population, and this in line with supporting the affected state to realize and implement and ensure that they can protect the human rights of affected or their population.
Y en este sentido,
in this sense, we are particularly interested when we hear you talk about obligations rather than responsibilities.
I presented the role of to stress the role of legal cooperation as a legal obligation.
Okay.
Yeah, sure.
Muy bien, muy bien. Muchas gracias.
Good, thank you. For world youth, for climate justice, you completed your first presentation, your first intervention, with a phrase. You said, you're talking about children, youth, and future generations, right? And you said, with respect to intergenerational equity, you talked about incorporating this concept. You're asking us to incorporate this concept. And you say it's in Article 19. It can be drawn from Article 19 of the American Convention. You also said that it makes reference to you said Article 4, Article 5, Article 26. Could you please explain in a bit more depth? Bring it specifically when you talk about the American Convention, and something you said at the end, future rights of future generations. Are we talking about future rights or rights of future generations? It's not the same thing. It's two different generations. Because you said literally future rights of future generations. Can we protect? We can protect them as rights, but the question is who represents them? Or instead, are you saying that through protection of children and youth, if we achieve that, we can then protect? These are two different things. Thank you, Your Honor, for this question. I know that time is short, so I will not take long. Mainly, I think that the relationship of these articles is that in the cases of climate litigation that have taken place before domestic courts and regional courts, it has been done, these cases have been brought under the idea, with the idea that there was violation of the right to life and to personal integrity for children and youth who are bringing their grievances. And this is because the states have failed in their obligations to prevent foreseeable damage. Based on what we read in science, science speaks of irreversible damage to health of present and future generations. And this leads me to the second point of your question, which is that this differentiation between being a subject of law and an object of law, we believe that this should be addressed, especially when we talk about future generations from the perspective of objects of law, where the states would be under obligation concerning future generations, and you don't necessarily need to recognize the rights of future generations, because we know that they do not yet have legal personality to call them that. Nevertheless, this does not mean that they do not have an interest, a material interest. They live on this earth, and they should be able to enjoy the same rights that we are all enjoying. And if we may, we can even see it in light of Article 26, more progressive rights, and also in light of the pro persona principle. We need to look forward from the perspective of policy with the intergenerational perspective. So this, I think, is, in general terms, this is the perspective that we hold. Of course, all of this, as my colleague said, Aditi said, derives from the right to a healthy environment, which, and the court has established this in two dimensions, individual and collective. Future generations, we believe, would come under this collective dimension, with this perspective that future generations are an object of protection, and therefore we can link that to the other objects of protection, such as nature, biodiversity, and it all needs to be interpreted holistically, because in that way the states would not otherwise the states would not have the tools to face this climate emergency. Thank you. Thank you for your answers.
Thank you, Jeff McGregor. I ask the Vice President if he has questions. Yes. The first question is to Professor Elisa Fornal. That goes along the lines of questions already asked by Judge Perez Manrique. And also, for the benefit of usefulness, I will try to be very straightforward. I did not fully understand the usefulness of the concept in dubio, well, the Latin name, when in doubt, for future generations, or to the benefit of future generations. And you are suggesting it is a combination of the precautionary principle and in dubio pro natura. But quite frankly and respectfully, I believe it's more one of these names that have come up also in the hearing that seem to be more sophisticated theory than real tools to be used. And here we are trying to provide tools to solve concrete problems. So my question is, how does that assist us, the use of this principle? Thank you.
Thank you a lot for your question. Yeah, our idea when we try to suggest these two principles is really to provide tools that allow states to mainly to resolve conflict in case of uncertainty, and also when I said before, the adoption and the inclusion of these principles, let's say principle, but as I say, interstitial norms, because they have no autonomy or normative autonomy now, is really to create a normative change when they are applied, and to allow state to change also, or to solve a conflict that they can have in case of conflict interest. And I think pro natura has worked quite well, and there are several cases at domestic law, but we don't have a formal recognition at the international level, so this I think could be an important opportunity. Also because the only mention we have at the international, as we say in our amicus, at the international level has been done in a dissenting opinion during all the cases in front of the International Court of Justice. So I think due to the development that we have seen, we see in the region, I think it could be a good opportunity. As I said, we suggested to move a little bit further, but the idea beyond these two principles is to work as a really interpretative tool that we can provide to the state when there are uncertainty or there is not possible to solve issues where there are conflicting interests at stake. So this was the main aim that we had when we tried to suggest them.
Thank you very much. And as my colleague has already said, with pro natura we are clear on it, but the question really is in favor of future generations. I have to confess I still have my doubts, but thank you, we'll reflect upon it. Thank you so much. And I have another question to the Ruta del Clima. I would also like to come back to something else I did not understand, and if you could please be very specific in your answer. How, going back to the funds, how would these funds drive structural violence? I still did not understand it. How does the current design, such as they are and they stand today, how could they further this violence? Thank you, Your Honor. It's related to the conditions of extreme vulnerability the communities are in. They are currently already suffering damages and losses, and how countries and communities that are already extremely indebted and have precarious conditions economically speaking. They have pre-existing conditions of vulnerability, and then the consequent damages of extreme events and slow onset events, such as in the dry corridor of Central America, droughts or hurricanes. These events have devastated the areas for decades. And the fund, although it could lead to non-reimbursable funds that could be delivered to countries, is actually dominated by financial mechanisms, so insurance or credit or loans. So it opens a possibility for these countries and communities, instead of receiving the reparations they are owed due to these damages that they legally have a right to receive, and for damages they have no duty to support, they themselves, and they're already doing this, they have to pay out of pocket, out of their national budgets for these damages, and they must seek new forms of financing, whether be it through credit and financial mechanisms, so that they can subsidize damages that were caused by third parties. And this will lead to social conflict. In communities currently, what we see is that many of these are women's communities because men have left. In Central America, it's very common to see in fishing or agricultural communities where there is a loss of the social fabric. And besides that, on top of it, you have indebtedness, which is basically what the fund is suggesting to do. The main pillar, again, are financial institutions, international financial institutions, who have an aim, as any type of this institution of the like, have to provide loans to states. So that's the socioeconomic dynamics we are talking about. And we are talking about communities that if I don't fish today, I don't eat today. If it doesn't rain today, I won't have crops. And if I go out to fish, I have no way to pay for the gasoline, the diesel I use for my boat. So to that extreme, societies in Costa Rica, Honduras, El Salvador, Guatemala, we are seeing this logic imposed. Financial services as a solution to what extremely vulnerable communities are suffering. Thank you very much. No more questions.
Vicepresidente, también a Ruta del Clima.
Thank you also for Ruta del Clima, and briefly, in the interest of time, you said that Panama has a system to identify economic pecuniary reparations with 16 indicators. Could you briefly explain how that program works? And you said other similar experiences that may serve as an example for this court. Yes, certainly. Panama does indeed have a system with 16 indicators. It's on the website of the Ministry of the Environment of Panama. Unfortunately, I haven't had access to the description of each indicator, but I am certain of this because I have spoken to people at the Ministry of Environment, those who were in charge of developing it and are about to implement it. So I would owe you an answer on that. And we also do field work with community monitoring, and we have developed indicators to work hand in hand with communities to recover first-hand data, so to collect those, and we can provide you with that methodology as well. And there are other studies in Bangladesh and in Nepal where loss and damage has been analyzed at length, and they're looking for ways to go about it. But one Central American government has, and that's Panama. That's an important milestone to be borne in mind. Also, it's important to say that under Article 14 of the Rio Declaration, and the Convention on Biological Diversity, experts are made to explain what losses and damage are in terms of biological diversity, and that could also be transposed to this case to see what considerations are to be taken into account. Thank you. I would like to see those data, so if you could please provide them to us. I'd like to thank all of you on behalf of the court for your submissions. Those were very useful for us, and as part of this very difficult task of issuing an advisory opinion of these proportions. We are going to break until 12 p.m. when we're going to resume with the second part of this morning's session. All right.
Buenos días.
Good morning. We reconvene this public hearing following the order established this morning and in preliminary meetings. I give the floor to the Center on Information on Business and Human Rights, the Association of Lawyers Social Bear Restrepo, Pax Christi International Program for Latin America and the Caribbean, and the Environmental Committee in Defense of Life. I remind those appearing before the court to please express yourselves slowly and clearly, both in your submission and then when answering questions to help interpretation run smoothly. Thank you. Warm greetings to the judges of the court. Before I begin, I wish to thank the solidarity and hospitality of our host state and, of course, the significant participation of civil society from all Latin America that, as always, has provided great energy in the Inter-American system of human rights. I am Fabiana Andrés León Peñuela, representing Colombia in the Center of Information on Business and Human Rights and the organizations mentioned by the President. The main objective of our submission is to focus on strengthening the inter-American system of human rights regarding the responsibility of economic actors and as to the respect and guarantee of human rights, particularly under the current climate emergency. I will bring 3 ideas that you might integrate into future jurisprudence and the advisory opinion, which would help us build solid inter-American environmental laws for the good of all communities, individuals, and nature. The first thing I'd like to highlight is an approach on the right to development as a determining factor to integrate in human rights under the climate emergency. We must consider that precisely the climate emergency is showing that states are really not materializing the right to development. To the contrary, all their initiatives are geared at promoting development that has gradually destroyed nature. And consequently, the right to a healthy environment is closely linked to that. Secondly, We invite you to include standards regarding the need to consider the role of businesses and the role of having more monitoring and supervision over their activities, as well as prioritizing accountability. Reinforced due diligence is necessary and should include participatory mechanisms, access to justice, and dynamic reparations as we have under the climate emergency. We would also like to suggest within the standards of the system to be used the Sendai framework for disaster risk reduction linked to the climate emergency. The disaster approach would contribute essential elements for decision making in a dynamic, ever-changing context such as climate. A static view on climate would not really reflect the reality. As for the right to development, I suggest the following elements. Development was a central aspect of the creation of the Inter-American system. It is part of the constitutional elements of its charter and one of the main objectives of the system, particularly the joint promotion of the development of economic, social, and cultural development. However, the approach does not really follow the inalienable exercise of peoples to full sovereignty of their wealth and natural resources. It has been used as carte blanche to impact and exploit communities many times in an unsustainable manner. This has led to the evolution of international human rights law as a relevant role for the inter-American system, and it is included in it to try and limit the exploitation of natural resources. It is clear that there's also a direction of public policy in the region where the backdrop is indebtedness, and certain clauses within bilateral agreements of investment impose burdens on states that limit their capacity to regulate the impacts of the climate emergency. This is an opportunity for the court to help guide states and to help them activate the necessary safeguards to correct the path the development matrix is following and protect their populations. It has been calculated that demands for investment in oil and gas may be ascending several $1 million, and considering these figures, it is necessary to have constructive dialogue with arbitration mechanisms and with the states that sign bilateral investment agreements to ensure they include international human rights considerations and identifying measures to protect safety, the life of people, labor rights, public health, and the environment, including response to climate emergencies. And considering the business framework, the guiding principles on business and human rights have provided substantial elements as to due diligence. However, we believe that it is not enough. We need to advance a mandatory due diligence approach based on the criteria identified by the Inter-American Commission on Human Rights in the report of 2019, considering elements such as adjusting behavior of businesses and companies to the guiding principles with an inter-American perspective, adopting plans to reduce emissions within the context in which companies operate, and minimizing their carbon footprint, not presenting obstacles to implementing environmental policies or actions, and mitigating and remediating negative impacts of their operations that might have been unavoidable, as well as those that could have been foreseen. To provide greater clarity on potential standards and obligations, we invite the court to consider the proposal by the Working Group on Human Rights and Transnational Businesses. They suggested 3 levels of obligations: the obligation to protect by the states, obligations to respect by businesses, and the obligation to remediate for both. In the first case, adopting an ambitious approach to reduce emissions, guaranteeing a fair transition based on rights, and to support defenders, to discourage greenwashing and undue influence of businesses in public policy. As for businesses, they have to adopt corrective measures urgently in their operations, and promote responsibility and engage with stakeholders such as indigenous peoples, and reducing the impact on human rights regarding the climate emergency, as well as promoting responsibility and refrain from greenwashing. And for the obligation to remediate, we have to have appropriate and effective measures considering intersectional and vulnerability approaches, building a solid accountability culture, and provide legal, judicial and extrajudicial recourses related to the environmental impacts and human rights derived from the climate emergency. The court should focus its efforts on characterizing extractive operations as high risk, considering the emergency. And regarding the Sendai framework in the Inter-American system, we believe it is essential for the Inter-American system to include this risk perspective, as it is consistent with the dynamic development of the climate emergency. And it means that we would have a response articulated by international instruments, but also a very concrete, specific response according to the cases and particularities of each territory and context. This would allow the Inter-American system to include elements such as size, frequency, concurrence, whether we're talking about rapid or slow onset, the origin, whether natural or human-made, and even a description of technological or biological threats and risks. Additionally, in order to improve the way the Sendai framework is applied, we suggest certain recommendations as to priorities included in emergency action plans or plans to respond to the climate emergency in the region. Urgency in understanding risks, strengthening governance to manage risks with clear and well-defined criteria, support through regulatory regimes that refer to the roles of state and non-state agents, and the inclusion of stakeholders from the scientific, academic, private sector, and civil society. And lastly, it's important to, from the Inter-American system, ensure companies assume business models that allow for shared prosperity, to truly commit to the public sector, and to have a relationship that helps us provide a clear due diligence approach, mandatory due diligence approach, so that states can adopt these measures within their regulatory frameworks. And lastly, including effective participation and fair negotiation with communities and workers with projects that are occurring or will occur in their territories, and also considering the damages and violations of human rights that are presented or may present themselves. Reducing GHG. Sorry. That, of course, means there should be a precautionary approach that is coordinated and open to risk analysis regarding human rights and the climate emergency, linked to the development of business activities and how these should take specific rapid measures to respond to this without becoming actors that go against measures by the states. Thank you.
Thank you for your participation. Now I give the floor to the Civil Association for Equality and Justice, the Center for Legal and Social Studies, Fundar, Center for Analysis and Research, and the Center for Economic and Social Rights, and the association La Ruta del Clima. You have the floor. Thank you, Madam President, Honorable Court. Good morning to all. My name is Julieta Levin. I belong to the CELS, and I am going to speak based on the amicus curiae that we submitted together, the organizations that you just mentioned. And it will focus on the role of fiscal policy in the face of the climate emergency and its impact on human rights. When we talk about fiscal policy, we're talking about resources available. And without resources available, nothing can be done about climate change. So for the steps to combat this emergency to be possible, it is essential for this honorable court to include standards about fiscal policy in its advisory opinion. This is fundamentally important and is an issue that is being broached at the regional and international level in several venues. And it's especially important for Latin America and the Caribbean, where fiscal systems are regressive because the tax burden is not proportionate to people's ability to pay, which affects the most vulnerable the most. And it is one of the most indebted regions with the highest level of exposure to climate change. Oftentimes, for states, debt obligations prevail over climate obligations, and countries allocate more resources to paying debts than to dealing with climate change. So this has to change. This is an opportunity for this regional court to be at the forefront of this issue. A key tool for the development of standards in this area is the initiative on fiscal policy that was made up of some of these organizations that I represent. They include human rights instruments in the area and have been signed off on the Inter-American Commission, and also include the Protocol of San Salvador. We would like to have you include that in your AO. I will first of all speak about human rights and fiscal policy and the need to mobilize as many resources as possible. And then I will develop the link between debt and climate change. And finally, I will submit our pleadings, our petition. The right to a healthy environment and other human rights is contingent on resources being available. Reparation for losses and damage caused by climate change also is contingent on funding. We need resources to fund the energy transition, and also have policies against climate change and for the transition. However, the structure that we have in place goes against the taking of these measures. We don't have a fiscal situation that is comparable to developed countries, where there are excise taxes that do not bear in mind people's ability to pay and are therefore regressive. Fiscal policy can contribute to guarantee rights by allocating resources, or else have inefficient or regressive regimes. The obligation to mobilize as many resources as possible means adopting a policy framework to ensure resource mobilization, and further taking measures to enlarge that pool of resources when necessary. That means increasing fiscal space through progressive tax measures, through resources that are being mobilized and that are lost due to evasion and corruption. And also they should be obtained through international cooperation. Based on the principle of non-regression, states must ensure that their fiscal policies do not lead to backtracking in terms of human rights, and this means exploring all possibilities of enlarging fiscal space before going into austerity. And now talking about CBDR, which has been mentioned once and again during this hearing, developed countries must provide financial resources to developing countries to meet their climate commitments. And this court could specify what the scope is of these CBDR in terms of finance. And going back to an issue that is a double whammy for the region, debt and climate change. The Latin America and the Caribbean is the second most indebted region over the last decade. There is a vicious cycle involving debt and climate change, because the emergency caused by climate change has led countries to take on debt to face this issue. Here, once again, CBDR. Our region that has made a negligible contribution to climate change is now suffering its consequences by receiving loans from international financial institutions or countries that were the ones that caused climate change. And thus that increases the burden of debt. Going back to Judge Ferrer Magrego's question, the court could indicate the need to explore different alternatives to loans to fund climate action, such as grants. So there's a need to fight climate change. In 2021, the lowest income countries devoted over 5 times more of their resources to climate change than those that are developed. And there are also situations that are incompatible with the fight against climate change. The economies that are based on the export of raw materials, as is the case of many countries in Latin America, foster overexploitation of the natural resources and extractivism and agri-industry. In Latin America, there are tax benefits and also subsidies to these industries, and they favor high income individuals and companies and end up being regressive and hurting those most vulnerable. The case of Argentina is a case in point. Currently, there is an adjustment being made to public spending affecting human rights and environmental rights. In the first Q of 2024, 96% less was executed on the environment and climate budget. But the tax benefits of extractive industries is never brought into question. There is a promotion of mining, for example. In 2023, over 58 billion pesos were not collected, which is the same as the initial budget of the former Ministry of the Environment. And the government seems to be happy with this model and overlook these things. This court can have a fundamentally important role in saying that the principle of debt sustainability must include an environmental dimension and human rights obligations, and should not be circumscribed, as is the case now, to short-term analysis as to whether debt can be paid or not in merely financial terms. And this has been said during special procedures before the UN. Debt cannot be considered sustainable. If to pay, you have to breach your human rights obligations and your environmental obligations. It cannot be a viable option to relax the standards of environmental protection to foster hard currency investment to pay the debt. And this is not just for debtor countries, also creditor countries, states, IFIs, and private financial institutions are also under the obligation for cooperation, due diligence, and precautionary obligations that make it necessary for them to carry out impact assessments before making recommendations and issuing loans, and making sure that the ability of the state to respect human rights is not undermined. This AO is fundamentally important in delineating, outlining the main obligations of the states to face the climate emergency. Climate change has especially great impact in our region and is a threat to humankind as a whole. And that is why financial issues must be included also as part of fighting climate change. In view of the above, we would like to request that when issuing the advisory opinion, it develops standards on fiscal policy to guarantee the availability of resources to face the impacts of the climate emergency, resources that must be collected in a progressive and forward-looking and sustainable way, so as to make sure that sufficient resources are available to guarantee human rights, and taking into account the CBDR and the need for international cooperation. These standards would once again position the court at the forefront of the international of the world, setting the course for the states and for other international organizations and tribunals that are dealing with this issue, which is an issue that will not disappear soon. It is here and will be for years to come. Thank you.
Thank you for your participation. We will now hear from the representatives from Eulalia, Petit, Gabriel, and Iraida Jimenez. May it please the court, I am Iraida Jimenez. I'm from the International Affairs Office of the University of Barcelona. Madam President of the Inter-American Court, ladies and gentlemen of the court, Assistant Registrar, representatives of the states and international organizations, Ladies and gentlemen, the climate crisis we are facing poses an existential crisis not only for enjoying human rights today, but also for the very survival of the human race into the future. This is why the critical question we should ask is, are the interests of future generations being protected by the obligations established in the American Convention? And are they adjudicable before the court? The answer is yes. This is why we want to emphasize some of the principles that will help us develop this position. First of all, the delimitation of the concept of future generations in the sphere of international law, which has evolved and has finally become an essential component for sustainable development, and also a critical factor, an indissoluble factor in human rights treaties. The idea that that intergenerational rights are being developed progressively as an intertemporal right, and there is has a means of access first to temporal justice and also to climate justice. This has been a bridge for including the principle of humanity and equity through the interpretive jurisdiction of for the Biodiversity Convention. This includes the interests of future generations and has been used in a number of different litigations, both domestically, such as Future Generations, Neubauer, the Institute of Amazonian Studies, and more recently, internationally, before the European Tribunal of Human Rights in Clima Seniorium, where there was the issue of uneven distribution of the burden for future generations, associating it with effective measures for making substantial progressive reductions of greenhouse gases. The guarantee of life, survival, and development of future generations is based on two main pillars. First of all, data-centric, and number two, multicentric or anthropocentric. The first has to do with meeting the ultimate objective of state sovereignty, which is nothing more than protection of the human community, which needs to include compliance with international standards associated with human rights, and this leads to protection of populations that are currently under the jurisdiction of the state and can be projected to future generations. The second pillar, multicentric. We should recall that the American Convention protects the rights of current people, but also is vital because of its intrinsic value. Faced with the failure to comply with convention-based obligations on the states, this is where intergenerational justice would take shape, first of all, from the substantive standpoint through the concept of life plans, which has been established by this court in its findings on reparations, but also in substantive law to life and personal integrity for children and youth. These are particularly vulnerable populations who are affected because of intersectional vulnerability. The right to life, which is enshrined in Article 4 of the Convention, is not limited just to mere physical existence. We find that there are current categories facing a significant, real, and imminent reduction of life expectancy as a result of climate change. Therefore, we must ask, what is a life plan if not an expectation to lead a decent life into the future, even faced by a grave material and imminent threat to human rights? We should remember that the incorporation of the life plan is an autonomous right, because the violation of the rights guaranteed in the Convention has an impact on life expectancy and therefore on future life plans. Therefore, it entails violation of Article 4, 5.1, 17, 19, and even 26. In the context of the climate crisis, in sum, the right to life and life plans are intergenerational guarantees in the framework of the American Convention. This, in no case, means calling on actio populares, because we see that legitimate and direct interests of current vulnerable groups are being undermined. The key of state obligations is based on the sustainability of conditions for decent life, where the state has the role as a trustee of this essential resource for the effective exercise of human rights with no specific temporal restrictions. Thank you for your attention. I will now ask Professor Petty to continue. May it please the court. My name is Eulalia Vladimir Petty de Gabriel, and I am appearing before the court as a professor of public international law of the University of Seville, Spain. As my colleague has established, substantive rights recognized in the American Convention for people currently living and existing guarantees or can guarantee the interests of future generations. From the procedural standpoint, however, the problems that the Inter-American system may face are different from those in the European system and those that have been described in the past few days. We're not talking about rights holders, whether or not people hold rights, because living people do have rights, or a question of standing or locus standi, because in the Inter-American system, any person or group can bring a petition. Rather, it's a question of identifying victims as a standard for admissibility, which is different from the standard for jus standi. The requirement for identifying the victim, nonetheless, is not contained in the convention. It is a requirement that is established as actionable under the rules of procedure under which a petition can be brought without identifying the victim when it's not possible. But the rules of procedure of the court establish as a necessary requirement the identification of the victim in order to process an application received from the Commission. Exceptions are recognized in the case of collective violations, and the court has developed in its case law this as a number of criteria for determining special circumstances under which this exception can be invoked. Bearing in mind the difficulty of identifying specific victims, in the sense that damage to life plans and the impact on future generations is uncertain, although it's likely and foreseeable. So we would propose to the court a number of different avenues by which it could move ahead in this area. First of all, to analyze in terms of massive or collective violations or that can be litigated because of the climate emergency. And this could be done without making any change to current practice. In the second place, explicitly amend your rules of procedure in order to allow a new exception as the elements the court must define for bringing applications before the court based on climate emergency. A third idea would be that the court accept the view already taken by the European Tribunal in the Swagens case of the potential victim. That is to say, when a whole chain of events occur that are likely, that are probable, and that culminate in a certain violation of the rights of the applicant. This situation, we think, is certainly present in this current climate, especially if we consider what factors should come into effect for this purpose. Why, in our submission, did we submit a discussion of the contentious jurisdiction when we're supposed to be talking about an advisory opinion? Mainly because of effectiveness. It has been shown in the past that advisory opinions from the court can lead to jurisprudential development by the court, but not only by this court, also by domestic courts, and also changes to domestic rules and regulations. The states are the primary are custodians of guaranteeing rights, and therefore the advisory impacts for judicial review based on the convention would lead to a number of steps that we think could be included in the process of protection. In the second place, our second reason is based on context. In this dialogue among courts, why do we feel that these systems where we have diversity of views and of assessment is important, also in the case of territorial damage? And finally, there's an argument based on timeliness. The advisory opinion makes it possible to engage in a debate, a discussion, and a biased discussion without viewing the real situation of victims, re-victimization, or circumstances that converge in the states. If I may, I would like to close with a personal comment. 24 years ago, on this same date, I was married, and I decided that every day of my life would be an April 25th. My husband, my daughters, who made it possible for me to be here and to develop my career, are my own life plan. We would ask this court to guarantee that children and young people can develop their own life plans, just as I have done. If they can't, there will be no new generations, my daughters, my grandchildren. Human status is necessary for the state. The human community is necessary for the state to exist, for the new leaders to exist. A human community will give rise to future courts, future judges for this court. Thank you for your attention.
Thank you to Eulalia Petit.
Thank you very much for your participation. I now give the floor for the International Code of Conduct, the Arias Foundation for Peace and Human Progress, the Institute for Sustainable Development Education, the Geneva Center for Governance in Security, the Legal Consultancy of El Bosque University, and the Institute for Studies in Development and Peace, and other experts. Go ahead. Thank you very much, Your Honor and judges of the court. On behalf of our association and the legal consultancy of El Bosque University and the other organizations I'm representing that wrote this amicus, the opportunity for bringing our contribution under point E on the obligations of states in terms of protecting human rights defenders, environmental defenders. We wish to highlight the role that private security companies have performed in creating risk situations in two scenarios. First, by providing services to companies of the extraction industry, and secondly, when they protect human rights defenders. These types of private entities provide military and security services covering a wide range of services such as surveillance, protection of people and objects with or without weapons. The use of mercenaries to violate human rights and hinder the exercise of rights to their self-determination, calling it the working group going forward, has stated its concerns on several occasions because these types of companies have been replacing services that were previously provided by the state. Even for the region, Latin America and the Caribbean, it is estimated that 2.5 million people work in these companies in some places, and sometimes even exceeding the number of police officers. However, the problem is that this is not a fully regulated sector. Towards 2009, the Inter-American Commission lamented the lack of regulation and the implications on human rights violations. We are currently still pending on the thematic report on the matter. And also recently, the Commission for the Truth in Colombia issued specific recommendations to do the institutional and legal reforms necessary to ensure effective control for these types of companies. These companies in the extractive sector, as we have submitted in our document, are silent actors, but determining the creation of environments of violence against human rights defenders and environmental defenders. The working group has highlighted the fact that in the extraction industries, companies invest billions of dollars to build and maintain as well as administer their extraction projects, employing a large number of people. And it is to their great interest to guarantee the security of their facilities and operations. So therefore, they must use different types of security providers for their own security or third-party securities, security officers, or security offered by the state. All types of security provision entails surveillance, sometimes intelligence, and even use of force. With a lack of clear standards and effective supervision, it is unavoidable for violations and abuses to happen. The Inter-American Commission, in several of its reports, has mapped and received information regarding multiple incidents throughout our region. They've even said that people live in fear in certain communities because of how these companies act, that private security guards participate in police operations and detain citizens or even evict them. There's been very serious cases in Honduras, Guatemala, Brazil, Ecuador, Peru, and even one of the cases in Colombia involves women that in a focus group said that the security personnel related to clean energy projects, including clean energy projects constituted a threat for environmental defenders, and they had even threatened sexual violence against women. So even companies providing solutions to climate change are also immersed through their security providers in these kinds of threats. The companies that provide protection services for human rights defenders can also be immersed in these types of violent spheres against defenders. It is more and more common for countries in the region to use mechanisms to protect defenders, which are material measures to protect them. By creating these mechanisms, such as in Colombia, Mexico, Brazil, Guatemala, or Honduras, they are part of the supply chain of private security companies. Vehicles, vests, drivers, armored vehicles, etc. So we have a case in Venezuela where the Public Prosecutor's Ministry is authorized to ensure that companies protect their citizens. Or in Colombia, the Commission in its report on the matter stated that civil society has denounced security companies that historically have been linked to self-defense groups are linked to the Defender Protection Program. The Commission, in its practical guide and recommendations for protection plans, has recommended these companies not to be linked to risk assessment, and that they have to be fully coordinated with protection mechanisms whenever protection measures are implemented for defenders. So given all the situation, we find that a determining factor is a lack of adequate regulatory framework. We must have regulations that are specific to these types of companies, and we need standards. And this is a great opportunity for the Inter-American Court to promote throughout the region these types of regulatory frameworks. We have a very important basis for this, and we suggest you may include this in your advisory opinion. The Montreux document on international legal obligations and good practices for states regarding the operations of military and private security companies during armed conflict. For two reasons. First, because countries in our region do have armed conflicts, for long-standing ones such as Colombia or new ones such as Ecuador. And secondly, because the instrument does not limit itself to armed conflict. It does have a very interesting and valid paragraph on good practices in times of peace, covering aspects from hiring and procurement to accountability. And because countries in the region have also endorsed the document, Chile, Costa Rica, Ecuador, and Uruguay. And we also have the International Code of Conduct for private security providers, which is complementary to the Montreux document. It is also in harmony with the principles on business and human rights, and it also provides a source of important regulation on the matter. This will allow to improve the ways to incorporate staff, ensure correct forms of procurement, hiring processes, background checks, supervision of training, quality indicators, liability insurance, etc., licenses, etc. I have a minute left, and I would like to add that indeed defenders, environmental defenders, are actually working on mitigation of climate change. The communities are there stopping machinery from entering their territory. Communities are the ones taking measures and taking steps that states are not taking by making or establishing more flexible environmental protection. It's the farmers, the indigenous peoples that are limiting the devastating environmental degradation. They're doing it on their own. So when they take these measures, after years, courts most of the time even give them the merit that they had a just cause for these demands and rejecting these projects. In the end, those who end up repelling and exercise and repressing defenders many times are the companies that are at the service of extractive industries. So it is very important to have regulatory frameworks for these types of companies and the way the conflicts with communities are managed. That's why we wanted to bring forward this topic to the table. Thank you.
Gracias. Seguidamente corresponde.
Thank you. Now we'll hear from the Center for Gender and Refugee Studies, International Refugee Assistance Project, Global Center for Legal Environmental Studies at the Elizabeth Hobb School of Law at Pace University, Sir Arthur Lewis Institute for Social and Economic Studies of the University of the West Indies, and Alianza Americas, Refugees International, and Shana Tabak. You have the floor. Thank you, Madam President, distinguished members of the court. My name is Felipe Navarro, and I'm honored to appear today representing the Center for Gender and Refugee Studies. I am joined by Professor Camila Bustos and Dr. Natalie Dietrich Jones, who will also be speaking, as well as by Mr. Jose Miranda from the International Refugee Assistance Project. Our presentation today focuses on climate-related displacement. I will discuss state obligations to address this issue when it occurs across borders. My colleagues will provide additional considerations relevant to small island development states and will cover internal displacement. While prevention and mitigation should remain a central goal, the reality of climate-related displacement confronts us. Although most people forced to flee remain within their own country, this phenomenon is increasingly transnational. Our submission emphatically calls for protecting individuals displaced across borders in the context of the climate emergency. This is echoed in over 50 other submissions, collectively underscoring the need to address this challenge through robust legal frameworks. International refugee and human rights instruments do offer a fundamental basis for protection. The UN Human Rights Committee has recognized that the obligation of non-refoulement under the International Covenant on Civil and Political Rights forbids states from returning individuals to places where their lives or well-being are threatened by the effects of climate change. Now the court has the great opportunity to reinforce the relevance of the right of non-refoulement as enshrined in the American Convention and the American Declaration in this context. We urge the court to ensure that this advisory opinion addresses state obligations in these four aspects. First, affirm the applicability of the right of non-refoulement in protecting individuals forced to cross borders due to threats to their life or personal integrity, humane treatment caused or exacerbated by the effects of the climate emergency. This is a matter of both treaty and custom, and as the court has recognized, is a jus cogens norm of human rights law. States must interpret their obligations accordingly and establish procedures to process the claims of climate displaced individuals. 2. Emphasize that a primary way for states to fulfill this is through the right to seek and receive asylum as enshrined in the American Convention and through complementary protection. According to UNHCR guidelines and as demonstrated by the work of my own center, many individuals displaced in the context of climate change and disasters qualify for protection under the Refugee Convention, the Cartagena Declaration, and human rights law. States must interpret their obligations to extend these protections effectively. Third, underscore that notwithstanding their obligation to protect, states should individually employ measures that can give them the flexibility to respond to enabling climate-displaced individuals to reach safety and receive adequate support. These measures can include offering humanitarian visas, temporary protection programs, and family reunification pathways. 4, advise states that they are obligated to cooperate in fulfilling their human rights obligations and have committed to do so through different instruments. Therefore, cooperation agreements between states should be leveraged proactively to address the needs of climate displaced individuals through measures such as improving migration and international protection frameworks and enhancing free movement agreements. The guidance from this court will be invaluable in shaping a principled and pragmatic international response to this pressing human rights need. Thank you. And if it please the court, I will now give the floor to Dr. Dietrich Jones.
Good afternoon, Madam President, esteemed judges and fellow attendees at this historical court sitting. I am Natalie Dietrich Jones, a research fellow based at the University of the West Indies in Jamaica. Today, I stand with all citizens of small island developing states, which are most vulnerable to the effects of climate change. I am pleased that through this forum, we have been able to cross geographical divides to hear the experiences of other states, such as Vanuatu. As we offer our final remarks on questions E and F, I would like to focus on question F3, which deals with forced displacement and migration. That is, what obligations and principles should guide the individual and coordinated measures that the states of the region should adopt to deal with involuntary human mobility exacerbated by the climate emergency. In our brief, we have argued that existing international and regional refugee and human rights standards delineate obligations and principles for states to protect persons displaced across borders, including those displaced in the context of the climate emergency. We also noted that successful mechanisms have been implemented across SIDS in the region, including mechanisms which have welcomed persons displaced across borders. The success of these initiatives points to what is possible through regional cooperation. It is notable that some of these mechanisms have emerged within a geographical space that is characterized by a weak human rights protection framework. Thus, within the Americas, there is greater capacity among some states to implement the court's findings. As the court formulates its response to our submissions, we ask that its deliberations on differentiated responsibilities also consider the distinctive human rights settings which shape the jurisdictions which will receive the opinion, in particular SIDS. The capacity to protect and enforce human rights is constrained by fiscal, technical, and human resource limitations in this special category of states. Therefore, should consideration be given to enhancing human rights frameworks with a view to strengthening SIDS' capacity to be...
I'm sorry to interrupt you. We have a problem here. The translation, can you please pause your presentation?
Sure.
Necesito por favor que venga el técnico.
We will just wait for the technician to come over, if you'll bear with us.
Please go ahead.
Okay. So, therefore, should consideration be given to enhancing human rights frameworks with a view to strengthening SIDS' capacity to be duty bearers to displaced migrants, both internal and cross-border? Could this be one element of reparatory justice? Such an approach would redound well to the wider landscape of human rights in Latin America and the Caribbean. In addition, we also ask that the court consider how it will engage with the different regional integration mechanisms, which will in essence be conduits for implementation of its ruling, where its jurisdiction applies. We urge the court to remind SIDS that notwithstanding the disproportionate impact of climate change, they remain duty bearers. Finally, we note that while the judgment will have wider application, that it may well require differentiated approaches in SIDS, not in the Americas. And I yield the floor to Camila Bustos.
Thank you.
Thank you, and good afternoon, Madam President and distinguished members of the court. My name is Camila Bustos, and I'm an assistant professor of law and faculty member of the Global Center for Environmental Legal Studies at the Elizabeth Hobbs School of Law at Pace University, New York. As my colleague said, we should not forget that most people forced to flee their homes due to climate-related impacts remain within their own country as internally displaced persons. Disaster displacements are usually mentioned as natural disasters, but it is human failure that is behind these disasters in many cases, and this obscures the way in which local and national governments are not meeting their human rights obligations under the law to protect residents. Economic inequality, poorly designed infrastructure and housing insecurity, coupled with inadequate disaster risk management, render people vulnerable and end up being forced to be displaced. As disaster scholars and affected communities painfully remind us, disasters are not natural, but rather the result of policy failures that fail to uphold the human rights of individuals before and during and after disasters. A few days ago, the Colombian Constitutional Court issued the judgment T-123 of 2024, which for the first time ever recognizes internal forced displacement due to environmental factors, including climate change. This decision establishes the obligation of the state to provide comprehensive protection to those affected, marking an important precedent for the protection of the rights of people affected by environmental events. Similarly, we respectfully urge the court to ensure that this advisory opinion address state obligations in the context of internal displacement related to climate change in three main ways. Number one, states must uphold the rights of communities to remain in their homes and guarantee their safe return and resettlement where possible. States must fulfill their duty to protect the right not to be displaced as a result of climate factors. Managed retreat as or planned relocation should be a last resort option. This court has already articulated states' obligations with respect to IDPs under the American Convention. We respectfully request the application of these standards to climate-related displacement. And finally, displaced individuals should not be subject to bifurcated regimes of protection that recognize and address displacement due to conflict or war, but ignore displacement rooted in climate or environmental factors. States must protect all internally displaced persons through human rights frameworks and not just through using the handout approach. Thank you.
Thank you for your participation. We will now begin with questions and answers by the judges. Judge Patricia Perez Goldberg, do you have any questions? Yes, Madam President, I do. Thank you. I would like to thank all of you for your participation. I have only a couple of questions because time is short, but first I would like to express appreciation for the thoughts shared by Professor Petit. It was very enlightening and inspiring. The representative of the SACE, you shared thoughts about fiscal policy and climate change. So I would like to ask you, based on the review that you did, whether you have any thoughts about the measures proposed, for example, by the OECD concerning carbon, but also they have proposed other measures. Do you have any particular view? Because the OECD has systematized a proposal in the line that you have described. Thank you for that question. Specifically on the OECD, I do not have information, but I do have about the information about the idea that tax systems also need to have a purpose. They need to be regulated. They need to be supervised. So when you talk about benefits for extractive industries, the Inter-American Commission has also said that these benefits are out of order, and also the IMF itself has talked about the benefits for contaminating industries as benefits that should be removed. Also, and at the same time, benefit industries that are useful for the transition. So this is our argument. Also bearing in mind that here in Latin America, unlike the case of the OECD, most of the tax systems are regressive. They do not consider people's ability to pay when taxes are assessed. There is a comparison that was done by ECLAC with the OECD, which found that the tax structure in Latin America, they found that 50% of income, of revenue, consists of taxes on goods and services, unlike the case of the VAT, which applies equally to everyone, regardless of their socioeconomic status. But for the OECD, these taxes make up only 1/3 of total tax revenue. So when we talk about progressive systems, we can look at the OECD countries, which are much more progressive than those we find in Latin America, which provides a useful parameter. Thank you. That's fine. The thing is, OECD has a whole body of recommendations, a very broad one, and it would be interesting to know whether you have an idea about that range. But I want to talk specifically about the Americas. Yesterday, we heard from Professor Desierto. I don't know if you heard her, and she was proposing a subject which was very interesting. That is the possibility of complementing the national domestic cases with the international legal system or justice system. Have you looked at how fiscal policy, tax policy in the countries of the region takes into account in its planning processes these contributions, these international contributions? I'm, of course, most familiar with the Chilean system. We have a direct mechanism through the law on the climate change framework, which considers financing, but there are also indirect mechanisms, such as the law on the environment, differentiated electricity fee rates, and so forth. Do you have a view about the Americas? That is, how the countries are financing the contributions based on planning, budget planning. That is to say, a specific breakdown in national budgets. And if they do, what good practices have you identified? I cannot speak in general terms about the region. It's information that I do not have. What I can suggest as a good practice is the climate action tagged and environmental action tagged budgets. In Argentina, we have certain budget items that have been tagged because based on how much is allocated to these items. But I do not have information on how this is measured. I don't have specific information, but I do know there's a research project underway, at least in my own country, that analyzed how budget expenditures are allocated to climate actions. In general terms, what we can say is that most financing that in any case needs to be received by Latin America through Article 9 of the Paris Agreement, that is where the developed countries undertook to provide financing for mitigation and adaptation, but most of it is loans. So the fiscal concerns, it comes from the same attitude, which is that in any case, the financing being given through the Framework Convention of the Paris Agreement merely builds debt. Thank you. No more questions.
Thank you, Judge Perez Goldberg. Judge Veronica Gomez, do you want to ask questions? Yes. To Mr. Fabián León Peñuela. You refer to the importance of dialogue with arbitrage and financial institutions and bodies, and we know that this is something that in the international community is like facing someone with several personalities. On a certain level, they talk in a certain way, and in another level, they talk differently. It's the type of thing that happens throughout. So more specifically, how should the dialogue happen in arbitration venues and in economic or commercial areas where these are being discussed? You're talking about business and human rights. So what we propose is a two-level dialogue. Of course, exchange of information among courts is part of how you build international law. But we also understand that in arbitration courts and venues, you have lex mercatoria as the primary force. And so it should be a two-way dialogue and an exchange with these courts. But such as in this advisory opinion, this court has, in developing its jurisprudence, it has the opportunity of guiding states in the development of law. So it could be the thread that unites the discussion, and when discussing bilateral investment agreements, free trade agreements, and general negotiations in these types of areas, to include specific human rights causes to safeguard and protect, and very particularly introducing the risk perspective. Because what we see in the general context is that there is an assumption that a company operating in a territory is neutral, and we need to include in that perspective and within that vision of states to negotiate the fact that any extraction projects, any project related to natural resource extraction entails risks, and for that you should preventively identify measures and build governance considering the impacts you may have. And with climate change or climate impact even more so, considering all the perspectives we've heard from many speakers, differentiated impacts, specific impacts in vulnerable communities. I understand, but as we understood it, there may be environmental assessment studies that are paid for by these same companies. So now you're telling me they're neutral, so you wouldn't even need to have this? Well, the dominant discourse states that the fact that the company goes to a territory has no impact on it. If you look at it from that perspective, when there's an environmental assessment performed, reality is divided into groups, and they are seen as isolated or separated. If you look at the socioeconomic impact assessments, there never are biotic or abiotic components of these, such as if people were not related to the environment. So when we say that there's a dominating discourse that seeks to be neutral, is the fact that business activity in itself already creates impacts, whether positive or negative, depending on the context. But it influences how communities live. It creates certain expectation, previous economic movements, and the operation in itself has environmental impact. So just to remove that veil of neutrality or impartiality would change the way these bilateral investment agreements are negotiated. So there's a whole area, you're saying, as to how to evaluate or assess the impact and how to assess risk dynamics. Yes. And there's a paradox, if I may. Many states, given their weak institutions, when analyzing the impacts, use those studies as a basis, and they let themselves be influenced by them. And the problem is that the risk analysis and impact analysis of human rights by companies, you see that there is an absolute lack of transparency as to how they assess impacts. And what we can see clearly is that any reading on impacts from the business sector is always from the profit and loss perspective and not on human rights. Lastly, for you, what's the role of the state in regulating companies and businesses, particularly in terms of emissions targets? The role of the state is absolutely essential, and here again the court has an interesting opportunity to considering the climate emergency, it could open the space, as we heard from our colleague Diana, to have new regulatory frameworks. Today, there's like a prior initial consensus that these scenarios of multi-stakeholder governance are lacking something, and states need more robust regulatory measures with very clear, concrete indicators of the emissions that are allowed or disallowed, what is understood as emission, because even if you look at it in the current context and with new developments for the energy transition, hydrogen in the region, for example, is talked about as being a good way to reduce GHG emissions, but in reality, we see that the science today proves there's no evidence to that. And what's happening is that in these supposedly new initiatives to reduce GHG emissions, old extractive activities are being promoted, coal, gas, and hydrogen in this sense. And within these regulatory frameworks that are still weak in our region, in spite of this, are there any good practices that you could highlight? I would highlight three. One, within the system, the initiative by the Inter-American Commission in 2019 of providing Inter-American guiding principles. It's very interesting in how it presents this and the array of topics it includes. And then secondly, the region is also betting on due diligence laws that are, of course, limited because it's just one procedure, but building public human rights policies and business and human rights policies, of course, with a more global perspective. And thirdly, framework legislation. There's initiatives in Brazil, for example, and Colombia. There's some discussion already, even in the civil society, to promote framework legislation on business and human rights. And the cross-border element, which is essential for the climate emergency. Is it included in these? Yes. One of the barriers to justice in business and human rights is extraterritoriality, and it's almost the question that asks us to reflect. And this is relevant because many of the impacts that we see in mining activities and even renewable energies are cross-border and transboundary. So I would highlight the discussion, for example, regarding mining rivers and the discharge of chemicals in rivers, and this type of mining does happen in transboundary scenarios. And also considering that we also should look to migrant labor and forced labor, which has to be linked. And also contamination. Thank you. Very quickly to Julieta Levin. You've mentioned common but differentiated responsibilities and said that climate change, the climate emergency, should order certain variables. You referred to fiscal matters. I know that given the nature of the discussion, when you talk about debt and external debt, we have cross-border elements. How, after all, the perspective you provided from the fiscal side and taxes was more of a national level, how can we include the global or transboundary effect of the climate crisis? Thank you for your question. If I understood correctly, what we should consider is first the obligations of borrower states, but also the obligations linked to the creditor states and to states when they act within international financial institutions. Obviously, the court does not have jurisdiction over international institutional financial institutions, but whatever the court says is very much valid, considering negotiations that will lead to that. So debtor states might be weaker with facing creditor states, and so if the court were to develop standards regarding sustainability of debt, in the sense that the sustainability of debt should be linked to environmental sustainability, and that debt is unsustainable if paying off that debt means you will not be taking measures to adapt and mitigate, or if it implies not being able to face climate change, then that's the essential or the core issue, sustainability of debt linked to environmental sustainability and human rights. Many times we've talked about or heard about environmental credits and how these could be compensated with debts. I remember some conversations a few years ago on this. Do states later use environmental credit to face the challenges of the climate emergency? It's a good point. There's much talk about the debt for climate action swap, that this debt be used for climate action. These types of swaps are not negative in themselves, but we should consider several aspects for them to be properly used. In most cases we've seen recently, they did not lead to a reduction of debt in states, and they did not really work as a swap for a significant portion of the debt states already had. So again, that is a problem. It's also, there's issues with accountability, transparency, the participation of different stakeholders to ensure that these swaps also help alleviate the debt. So it might be better to talk about debt reduction or debt relief for climate action. So it seems that we are still lacking international regulatory and national regulatory frameworks. Yes.
For Eulalia Petite Gabriel, thank you for being here on your wedding anniversary. Thank you. You talked about standing and identification, and also being bearers of rights, and you talked about this before the court. This might not be the most serious concept that has been referred to over the last few days. But what has been referred to is the fact that people don't have much of a recourse other than to resort to strategic litigation about the climate emergency. So aside from your advice to the court, and also about convention-based review, and this has been used already by the court, I mean, in past AOs, but the main thing is access to domestic courts, isn't it? Do you have any thoughts about this? Yes, absolutely. And I'd like to add, thank you for your question and for the opportunity. First of all, I'd like to say that I'm here thanks to my family. And secondly, this is not advice for the court. These are proposals or suggestions based on our own examination of the analysis of the possibilities in front of us and of the court. Of course, the court knows a lot more than we do when time comes to come up with alternatives. As to access to domestic courts, which has been talked about, there are several problems. One of them is difficulty of access, especially for children, as has been said. And another matter of great concern to me, specifically, which is part of the European case law, is access to courts with regard to the principle of extraterritoriality when that is applied. Because if we want to apply rights with this context, and let's say a Barbadian national wants to file a complaint against Brazil, I mean, the possibility, the fact that the person can't litigate in Brazil means that they'll have no access to the system. And these are issues that must be considered by the court quite carefully, because the issue of extraterritoriality may seem very attractive as a means of guaranteeing the set of rights, and there are certain diffuse rights here. However, it may lead to greater problems. The difficulty faced by the territorial state where you can litigate, which is your own, if you add to that the requirement of having to litigate in the defendant state, that means that you are multiplying the difficulty, exacerbating that difficulty that you just referred to, Your Honor. So I don't have the solutions. I am not a legislator either, but these are problems that are intertwined and that cannot be taken in isolation easily. Victim identification, exhaustion of domestic remedies, and extraterritoriality. We've touched upon only one of those points, but I think that there's a need for a systematic analysis from the strictly legal standpoint as to what the difficulties are that for something that might seem as an advantage initially. Thank you, Judge Gomez. Judge Perez Manrique, you have the floor. Thank you, Madam President. We've heard with great attention, with great interest to everything that's been said. And first of all, I'm interested in the issue brought up by the Center for Gender and Refugee Studies about displaced persons for environmental reasons. And I am going to ask you to focus on the following. We have international legislation or law that about migrants and displaced persons, and we know about that. You brought that up in your own submissions. My first question is, aside from the legal framework, the challenge in defining this category of displaced persons for climate reasons, or climate-induced displacements. Why am I saying this? Because people migrate for several reasons. And we might have actually 2 or 3 categories that come to mind. They migrate because their life is at risk, a matter of safety and security. They may migrate for political reasons, or for, and this is third category, accounts for most of the migrants, is for financial reasons. So what allows us to identify environmentally displaced people as a category, which is something that you talked about in your presentation. Thank you for that question, Your Honor. I fully agree with you. People are forced to migrate or are displaced for several reasons. It won't always be for a single reason, but there might be a combination of such reasons. As we see it, the climate crisis is a displacing agent in several ways. It could be directly through a hurricane, for example, that destroys a person's community, home, or where there may be direct effects on the person per se. And also, when it becomes a multiplier of such risks that force people out and to flee. And what we'd like to underscore is that the climate emergency must be borne in mind, and so must its effects as part of this comprehensive analysis that is going to be done case by case for in protection requests. What we've seen in the analysis undertaken by our center is that people who are forced to migrate can qualify for protection under the Refugee Convention. For example, imagine after a disaster, if there is no efforts are made by the state for assistance that is equitable and relief that is equitable across the state, and that some people are more affected than others, as was said by others in this session, as we see that certain rights are breached that are part of the right to a dignified life. And we see that this effect is the consequence of discrimination on the part of the state, then that becomes something that is liable for a refuge request. If we think about the Cartagena Declaration and events that seriously disrupt public order, UNHCR has said that the state must protect law and order, freedoms, and the population in general. And so that's whenever, in the context of a climate emergency, when an event takes place, be it a rapid onset, fast onset, such as a hurricane, or a slow onset event, such as a drought, then that can have an effect on law and order in the country, and or at least for some communities and some persons, and that should be considered as part of the universe of analysis to see whether the person should be protected from refoulement. So along those lines, I'm still interested in asking you about the obligations of the state in the framework of their obligation to respect and guarantee human rights. So clearly, the general legal framework of protection in cross-border cases such as these would be applicable. But do you believe that there might be problems involving the international legal framework for the specific protection of these displaced persons? And I'm talking about the principle of non-refoulement, and other principles having to do with migration policy in a part of the world where migration is a very important phenomenon and very widespread. So in the specific case of displacement due to climate change and across borders, that is, that the court should suggest as a standard a legal changes, I mean, at the national level?
I would say, to begin with, that we would ask the court that the states should interpret existing treaties such as human rights or refugees in the light of the climate emergency. For us, this would be a basis, and it upholds what we said in our comment, which is that it's true that the system, the internet, there is no specific international system for climate displaced persons, but it doesn't mean that people are not protected. Human rights standards and refugee laws already provide protection, as we have said. The states can take additional measures as well to reinforce the system of protection and to expand protection more clearly, more specifically, for people who are climate displaced. This is something that we understand that the governments of the region are discussing, among other things, in the discussion of Cartagena Plus 40, which is under discussion soon in Chile. In this case, how would you apply this case of environmental displacement and the principle of responsibility, of shared and differentiated, common and differentiated responsibilities? What's the interconnection? Thank you, sir. That's a very good question. As you have probably noticed, this is something that we did not address directly in our comment, in our submission, but we understand how important this question is. I would think that, again, let's start with the idea that all of the countries are have the obligation to protect, and my And Dr. Dietrich Jones said this as well. We understand, however, that not all the countries have contributed to the climate emergency to the same degree. So we reaffirm the principle of the law of refugee law on shared responsibility, where the states, the developed states and the states that have contributed more to the climate crisis can support developing countries, first of all, through efforts of mitigation, as we have been as other speakers have said, but also supporting these developing countries that are receiving climate displaced persons in order to strengthen their protection systems and strengthen their social systems in order to receive these populations. The climate crisis and the climate system, the common and differentiated responsibilities entail something else. I think there could be an opportunity for the shared responsibility under the refugee law could intertwine with the common and differentiated responsibilities that we see in the climate legal system, and we could see this as a way for the states to commit to receive more people who have been displaced because of the climate impact, be it allowing access to their territories or receiving them as refugees, temporary evacuees. There are a number of resources that could be used. There are proposals such as the Conference on Immigration, the NANS agreement, which can provide a basic guideline, and the same thing is true in Central America. Thank you for your answers. I closely followed the proposals by Professor Petit, Professor Gabriel, and Professor Jimenez. I would be interested in hearing you. You talked a lot about intergenerational justice. I would be interested in hearing you discuss your own concept of future. What are we talking about here when we discuss future generations? Along the same lines, you offered a proposal about determining possible victims, because this, you said it very clearly, this is associated with the idea of active standing for bringing grievances. So here we talk about the potential of victims. It is not a matter just for the court. It's a matter for juridical construction that is standing. I would like to hear you talk more about that. May it please the court, thank you very much for these questions, Your Honor. Judge Perez Manrique. With respect to the concept of intergenerational justice associated with future generations, in our paper, we started with the idea that future generations are the ones that have not yet been born. So our interest is to link their interests because they do not currently hold rights, because they don't have any existing legal personality, but associate that with the rights of people who do exist. And clearly, with the life decisions made by our young people, our children and young people, will these generations exist or not? When we see the decisions they're making, and will the state decisions make it possible or not for their life plans to lead to future generations? So that's the position we've started with, and that's the concept of future generation. Regardless of the idea of intergenerational justice or equity, that has other dimensions and other applications. That is true. For example, the analysis about terminology that we saw about in dubio pro future generations, we can use the fact that future generations could be overburdened or could be experiencing the effects even greater than those we are experiencing now. So when you need to weigh a situation limiting current rights, as in the case of Ubonet, we would then choose for the good of future generations by constraining current rights, but that's a whole different assumption. If we talk about intergenerational justice, we're talking about weighing the limitations on the rights of people now living. What we're studying is something else. It's an analysis of how we can protect the interests of future generations through currently existing rights. All of this fits into the system. They are simply different legal situations or problems. As for the concept of potential victim, this concept, for example, in your 1989 case in the framework of the European Tribunal of Human Rights, in this case, it was applied to a German citizen who had committed a homicide in the United States. The judges are familiar with this. This construction was used subsequently, for example, in the framework of the principle of non-refoulement, to develop the idea that a person currently in a state not subject to the convention who could be expelled, whether that expulsion constitutes an act of torture or jeopardizes the person's life, whether it's a violation of the convention. There's a whole chain of action here, so it's theoretical. The relationship but you can see the relationship to the climate situation. Every step in the cause and effect. It helps determine who is responsible, and there's no clear certainty that chain will actually be finalized, reach its logical conclusion. But even then, the court felt that there was, in fact, a potential victim, and therefore it decided to protect this potential victim by declaring that there was a violation by the state. In this case, the Human Rights Committee. In this case, it would be the American Convention. So, thank you. Thank you. You've been very kind. Clearly, there are no homogeneous concepts about future generations, right? That is very clear. And finally, I would like to ask a question about the access to information on companies and human rights. Unquestionably, there are many different derivations of this case. There are the whole issue about responsibility of companies concerning human rights could lead in many directions. They could be read in many ways. But I would be interested in asking you about one of the suggestions you made, that is, the possibility of declaring certain activities as high-risk activities. How would that work? How would that principle work? If we have an issue here that's associated with, I would assume, first of all, these companies have always required prior authorization from the state, a permit, under certain conditions. But what would be the consequences, please? Perhaps you could talk about that. Yes, let us say I could give you an example and talk about how the measures could work. An activity that is not always associated with the climate emergency, that is always associated with the climate problem, is mining. But mining has become a determining factor that makes a negative impact on the climate emergency, especially mining in the Amazon. So there's a contradiction here in every sense of protection, which is that in the first place they say we need to preserve the Amazon because it makes it possible to capture carbon, and therefore it's a strategic ecosystem. But the state at the same time issues permits for mining in that territory. So with this example, we have an activity that apparently is not associated with climate. Maybe it doesn't even emit any greenhouse gases. It's not associated with climate, but its operation in this case does have a significant impact in a scenario where that could be mitigated. So what can the state do? How can the state take measures? First of all, we have the possibility of implementing moratoria in strategic territories that need protection. Another would be that the companies themselves should incorporate into their own business plans, in their whole value chain, the whole issue of the climate emergency is a central issue, and particularly everything associated with emission of greenhouse gases, but primarily a clear understanding in their supply chain that there could be partners or trade or business partners who in principle do not have an impact but would in fact generate an impact, such as the example I just gave. In the third place, invite the states to develop scenarios and mechanisms of information and transparency that are much more robust and would make possible to find all the information that today objectively is being generated by the companies, but that is not publicly available, but should be. Because very often, as you have said in your own case law, are operating in the territories of countries that are weak institutionally speaking, and it's these countries that capture information and have information about territories and can make it public. And in this sense, as you yourselves have said in your advisory opinion on the right to a healthy environment, would make it possible procedurally and materially to lead to the effective exercise of this right. In this environment, in this same context, what about the right to development? How would that work? It needs to be a sustainable right in the context of the climate emergency. And how would you condition the players in the case of a company? Here, thank you for that question, Your Honor. It's important here because it makes it possible to do a number of things. First of all, the right to development, as we have said, goes hand in hand with the system itself. It's an integral part. It's a catalyst, because the right to development, as you said, is the sine qua non principle on which democracy is built. So if you put it into practical terms, how do you make that work? First of all, the need to guarantee effective participation by the communities that will be affected by projects, especially extractive projects. This is a critical component, because it makes it possible to develop their rights as part of development, which is the right to science and the ability to coordinate scientific knowledge and the knowledge available in the territory, so that do this in making decisions about policies. This could be much more effective if the communities themselves are the ones who understand the specific impact on their territory. But of course, I would also invite you yourselves to develop measures and proposals in the fiscal area. This is very important. It needs to be done, and remind you that the Inter-American Court has been a bastion and a lighthouse in international law on a number of occasions, and this is one of them. You have been very creative in the past, and you can be again. And I would remind you that it was the case law development of this court that launched the possibility for participation of victims in the environmental impact studies. And you can do that. You can be urged, and I would invite you to be to make the Inter-American system the one that can push for robust regulatory frameworks involving companies and human rights. That's inspiring to me, because you've talked about our ability to be creative. So I would ask then, how do we apply our creativity to the principle that the polluter pays, internationally and domestically? Internationally and domestically, polluter pays.
The polluter pays principle has the potential to work, but it has adverse elements as well, as it only considers short-term impacts and quantifiable impacts. But if we're talking about the climate emergency, these are progressive, cumulative, sometimes permanent damage that objectively you couldn't really say if you emit a certain number of gases, it's fine. And this is also to do with the implementation of the RED Plus instruments and other tools, such as carbon credit, that are imposing certain types of procurement that is unfair, certain forms of production and illegal appropriation of territories. So beyond that principle, I think you have the opportunity of developing the correlation between the precautionary principle the development and the right to science and building plural knowledge. And finally, very fundamentally, part of the proposal we've sent, introducing a risk-based approach and disaster-based approaches to face the impacts that are not going to be focused on a certain moment of in time, but they vary based on different conditions and situations. So creativity is more towards that, to find a much more dynamic system and not the traditional doctrine of principle equals rule, but how principles interact in multiplicity of rules. Thank you very much. No further questions. Thank you, Judge Perez Manrique. Judge Ferrer. Thank you, Madam President. Since you have called on us, help us with our creativity. During your submission, you've mentioned risks and also investment treaties. Risks to human rights in the context of the climate emergency. What do you think this Inter-American Court could help in that sense, in our advisory opinion? What could we call for? I would call for three things. First of all, relating the principle of cooperation among countries. I think it's part of the backbone of the inter-American system, and it's really an invitation for states within the framework of investment treaties that they negotiate with third parties to consider their negotiations may have impacts on neighboring countries. That's not happening today. These types of treaties and agreements are not signed with that in mind. So this is something the court could call states to remember. Secondly, I think it's important for the court to call states to review the way they are building the principle of legal security. There has been much a very contractual approach in that sense. So very important figures such as a declaration of public usefulness or utility have been perverted and become tools such as in my country, Colombia. Mining has been declared publicly useful, even though they are not taking into consideration communities that have spoken against these types of mining or imposing mining activities without any type of consultation. Again, here you have a wonderful opportunity, and you can help drive this. There should be a real objective way to bring mandatory due diligence to the inter-American system. It should be binding, and it should have at least two instruments you could stimulate in the context of bilateral investment agreements. One, for there to be a possibility to include clauses to void contracts when these do not consider real objective impacts on climate and human rights. And secondly, to include the possibility of negotiating clauses that open venues to renegotiate agreements, including the risk-based approach as a way to force the renegotiation of contracts. So incidents related to climate change should be a criterion to include in contracts that could accelerate renegotiation to lead to substantial change. Thank you. Thank you. To the representative of CELS, Julieta Levin. You've brought an innovative topic here today. It had not come up before. The debt and the climate emergency, and the fact that international financial institutions play an essential role to have the money that helps us fight this emergency. It has somehow already been covered by the questions by Judge Gomez, but could you please elaborate? What obligations do you believe these international financial institutions have, and what is the source of such obligations? Thank you very much for the question. International financial institutions, for example, the International Monetary Fund being one of the main institutions of the sort, have the Charter of the United Nations as their foundation. So protecting human rights is an essential principle or within that. So if you look at their incorporating treaties, they include human rights. Beyond that, within the UN framework and looking at independent experts on foreign debt and human rights, have developed several valuable documents and guiding principles on the matter. And they highlight one of the main obligations of these institutions and even other types of creditors, which is the obligation to perform impact assessments, how the debt will impact the countries, the borrower countries. And here I go back to what I mentioned before on debt sustainability. If you analyze the sustainability of debt, today these analyses are just based on financial or economic aspects, such as whether or not I can pay it off, without considering that the payoff might be if I cut back on all types of funding for human rights or the environment. In 2021, for example, in Argentina particularly, the surcharges for the loan, not the loan itself, of the IMF in 2021 were the equivalent of the whole budget for the Ministry of Environment and the Ministry of Justice and Human Rights. So it is an enormous problem. The resources allocated are insurmountable, and that's the issue with sustainability. How can we enforce this? It's very hard. Ideally, there could be some sort of dialogue between the standards of the Inter-American Court and other human rights protection standards with international financial institutions. Ideally, they would speak to each other, but that's where we're headed. To add to this, we should also remember, in the case of the World Bank, for example, that the mandate of, or the board of the World Bank has as board members the states themselves. So the way this institution operates is how states operate. So it's not removed from that. The same interests operate, and different from other institutions where there might be a separation between management and shareholders. We don't have that in the World Bank. What avenues are there for public or private financing that could help vulnerable states avoid accumulating more debt? Today, 80% of climate funding is through loans, so more debt. And that's why most of the civil society organizations that work in these topics are saying that financing should work on the principle of common but differentiated responsibility. No more loans, but subsidies, grants, which are in a way a form of reparation, considering the pollution, the contamination that debtor states were not responsible for. Thank you very much.
I'd like to echo the words of congratulations to Professor Petit and her family. They're probably watching us. It's 8 p.m. over there in Seville. So you were talking about 3 avenues, right? And I thank you so much for that and for going into our rules of procedure, because in adjudicatory cases, we'll have to face this. And it could be done, you're saying, through Article 35.2 of your Rules of Procedure about litigation and collective victims, or through a reform to Article 35.2, an amendment to it, or else do what the European Court did through the potential victim jurisprudence. So you've talked about potential victims, you're familiar with our rules of procedure. So if we had to reform our regulations, how would you do that? Our rules of procedure, how would you do that? Well, that calls for a PhD thesis, but if it please the court, and thank you for your question, Your Honor, if there were a need to amend the rules of procedure of the court to prevent, to contemplate an exception, I mean, to the climate emergency, in spite of the criticism that has been leveled at it, I don't think, one thing is having the criteria, the different thing is seeing how the European Court established those criteria in Clima Signorin. And this affects jus standi, and we're not talking about standing here, but still, at the end of the day, the idea is to define whether what a victim is, the status of victim, and when it's required. So an amendment, a reform where you could combine potential victims, that notion of potential victim, and if you'll bear with me for a second to avoid making a mistake, in paragraph 487, the European Court said that the requester should be exposed to a high intensity of effects of climate change, so that it's not a ratio popularis. It has to be a group of the population that is especially affected and at a high intensity. So there's the issue of the threshold set by each court, and also how to determine the burden of proof of that exposure. And burden of proof is something that has come up over the last 3 days. I'm not going to go into that, but all of that could be part of that discussion about that reform. And this paragraph also says that there should be a pressing need to ensure individual protection of the petitioner in relation to the absence, or non or of steps or measures to reduce the damage. I don't think that's exaggerated, actually. And so I'd like to see how to determine the burden of proof and the level of the burden of proof, but still, so that it doesn't become a ratio popularis. But here, the damage has not yet occurred, so that's in combination with other options, and it could inspire a possible exception, maybe, to be included into the rules of procedure when you cannot prove the existence of damage itself, because it's something that would happen in the future, and who knows whether as part of a plan, life plan, people will have children or not, whether future generations will exist as unborn generations. I mean, but still we can determine that there is a potential victim. Or maybe the exception would be the identification of the victim, or at least there should be some specific elements having to do with the causal complexity involving these climate emergency damage. Thank you. And Professor Jimenez, going back to the life plan, you said an autonomous manifestation of a life plan. What does that mean? Thank you for your question. When we refer to a standalone manifestation of a life plan, what we mean is that any type of breach of the convention may lead to the impairment of development of future life, and it will no longer be a form of reparation. And when the violation of the convention occurs, then this effect on this impact would be would be generated on present and future generations. Thank you. And now going back to a question asked by my colleague Perez Manrique for the Center for Gender Refugee Studies. The issue of obligations, meaning CBDR, so community visas. So could you refer to that about cross-border migrations and this issue, humanitarian visas, and they're so complex. You mentioned this, but could you elaborate on humanitarian visas? Of course. Humanitarian visas can be used by states to facilitate access and entry of persons who are displaced by the climate emergency. And this would be used, this has been used at a low level in some countries in the region, if I'm not mistaken, Brazil, and maybe others that escape me at this moment. There are different programs that may be modified or expanded somehow so as to specifically include this population. And what I have in mind is specifically the United States, which is where my center is based. The US has a parole program, which is an entry program designed for certain nationalities such as Nicaraguans, Haitians, Venezuelans. So these programs could be expanded to include the specific needs of persons who are displaced due to the climate, and also temporary protection formats maybe. In the United States, there's the temporary protection status, which offers temporary protection to or provisional protection to certain populations when there is a disaster that affects law and order in their country of origin. These programs are used very sporadically and in a way that is not generous and doesn't guarantee rights. Part of our advocacy in the United States and in other countries is to try and include a climate displacement as part of this migration mechanisms that are already in place. I have another question about displaced persons due to the climate emergency. Are there legal differences vis-a-vis other types of displacements or disasters having to do with the climate directly, and others that result from disruptions to law and order as a result of climate change? So are there differences in determining how to determine those?
Perhaps not exactly differences, but in the determination of how it affects, whether or not it affects public order or whether there are human rights violations. What are the factors? The effects of the climate, so that the effects of the climate emergency could be included comprehensively in that analysis. It should be comprehensive then. Yes. Very good. No more questions. Thank you, Your Honor. Thank you very much to all of the people and organizations who have taken place in this block. Thank you for your valuable contributions to this court. We will now take a break until 3 o'clock this afternoon before we continue with the rest of the hearing for this first part of the hearings on this advisory opinion. Thank you. Please rise so the court can take its leave.